All right, welcome everybody. This is the notice to students for the virtual broadcast of CE classes for GREC approved classes. With this school, the Georgia Real Estate Academy, has gotten approval from GREC to offer CE credit for our classes that had already been approved through a classroom. The school is GREC number 6915. This class is title exams, surveys, and title pitfalls. GREC course number 60192. We are so excited to have the instructor as Amy Davis of Davis & Associates Attorneys at Law, LLC. There's no required homework or written exam for this class. You must be on time and present for the whole remote virtual broadcast instruction. We are going to use the chat feature again for you guys to enter in your name, email address, and license number, as well as for you to answer questions. Please do not use your audio to ask questions until we get to the break or at the end. You will receive, per GREC, you'll receive credit for any one specific course number once every 12 months. There's no recruiting for any real estate brokerage or firm. I am Dana Sparks. I am the director of the Georgia Real Estate Academy. Heidi Kelly is the coordinator of the school. There are our email addresses. Please take a moment and jot down our email addresses, especially Heidi's. If you have any issues or any questions, you may email her with the course you are in, your email address, and your real estate license number.
Hello, welcome. It's early morning for title work and title problems, but we're going to get through this. As Dana said, I am an attorney with Davis & Associates. I'm the founding partner here. We have a lot to go over. I am going to share my screen at different times, and then there's going to be times where I'm not sharing my screen with you and just walking through some things with you. The first part of this, I really want to work on title exams, title issues, and surveys with you all. I think one of the most failed things that we do not protect our clients on is by not getting a survey and recommending that they not get a survey. We're seeing a ton of survey issues coming up over the last 2 years, really. So I want to go over some of those things that we're seeing, and I'm going to actually show you some different surveys that we have reviewed over the last number of years that I've just set aside that are common problems that we see and sometimes not so common problems. And I just want to talk to y'all about a lot of those parts of what we do. I am going to go in and try to share my screen now, Dana, if I can do that. If you'll give me 1 second.
There we go. Got it.
Okay, can you see my screen? Okay.
Yeah.
I don't know what that is, so I don't want to delete that. So where we're going to go right here is can you see that now?
Yes, ma'am.
Okay, great. Okay, so this part of, this is just sort of what we're going to go through with you today, and it shows what is the title exams and how title examinations work. So I'm going to start with that piece of it. Doing this interactively is a little bit different, obviously, than having you guys face-to-face where I can pass out a bunch of paperwork to you to go over what we're seeing and to go over what you're looking at. One of the biggest issues that I see in our industry is what a lot of law firms don't either know or don't participate in or don't abide by is really the Georgia Bar rules for ethics for real estate transactions. And one of the biggest things that I see that makes a lot of difference in the way that closings are handled from one law firm to another is how they handle their title examinations. The State Bar Rule of Ethics recommends 50-year searches that are completed in the counties. Right now, what we're seeing is a shift, and even during this time with the COVID-19, what we're having to do is a lot of online title exam searches. There's a lot of behind-the-scenes maneuvering to make sure that we're protecting our buyers, to make sure we're doing everything completely possible to make sure that they're getting everything that they need for a full title exam, to make sure that we're doing everything right. So where we start is the county records and indices. And so when we go into the counties, what we're actually doing is pulling the deed books. And if you've never been into the counties, when all of this is over, I recommend that you at least go by there one time just to see what part of the title exam looks like. They're huge books, and we go through those books and find the chain of title for our property, and we look back and forth through the indexes. One of the other big things that I think a lot of you all as realtors don't realize that we do, or maybe some of you do because you've been in one of my classes before, is not only do we run sellers' names and information, we're also running the buyers' names and information. Now, why is that part important? And it's extremely important for the lender to know whether the buyer is, for example, participating in some form of a lawsuit, being sued, or as a plaintiff. It's extremely important for them to know if the buyer has IRS tax liens that maybe aren't on their credit but are of public record. Georgia Department of Revenue tax liens are often common, and lawsuits with creditors, because you may have a creditor that shows that they had some late payments, which maybe didn't negatively impact their credit so badly that they can't still get a loan, but they may not realize that there's actually a lawsuit filed on a credit card, for example. So in addition to just looking at the county records for the real property chain of title, we're also looking in the magistrate court, the state court, and the superior court to see if there are any things that's showing up. We also check probate court to determine whether or not we have proper ability to be able to change title over if there's a probate matter. We're looking specifically, though, for open secured loans. One of the most common things that I use title insurance for is for insurance over a open secured loan. I want to talk to you about this just briefly because I think this is where we get hung up on a lot of title clearance issues with you all as far as the closing process from contract to close. When we look at open secured loans, we're looking at every single possible loan out there, whether it is a primary mortgage purchase loan, which is your typical FHA conventional or VA loan. But then we're also looking for other loans like equity lines of credit. And then we also are looking to see, are there UCC issues out there? Now, with the typical loans, we are able to find, let's say that someone has a loan with one of the big box banks, Bank of America, Wells Fargo, something along those lines. We're going to pull that and we're going to be able to go back to the seller and say, hey, we're showing that you have a loan. We need the information for that loan to obtain the payoff. When there's another open secured, let's say that there's an open secured loan for a prior owner, because this comes up often. If there's an open prior loan against an owner, there's a couple of things that we typically do. One, we're going to go back immediately to the preceding law firm and ask them for proof that it's been paid.
Hey, Amy, sorry to interrupt, but your slide, the left side is cut off, so I don't see the word before problems, and your 1, 2, 3, 4, 5, 6, 7 is partially cut off as well on the left side. And other people are saying the same. There you go. Perfect. Thank you.
Mm-hmm. Okay, so one of the big issues that we see with the loans is the type of loan that we find that's open of record. So sometimes the open loan is just, a first primary mortgage loan that we have to pay off, not a problem. But when it becomes a little bit more tricky or a little bit more difficult to obtain clearance on is when it's against a prior owner. What a lot of you maybe understand or maybe don't understand, or that you maybe haven't seen yet, is in the foreclosure boom, and Dana and I have talked about this many, many times over the last year or two. In the foreclosure boom, a lot of the title exams that were conducted during the foreclosures only went back to the current lender that was foreclosing when the buyer bought it, or to one prior owner beyond that. A lot of these were not 50-year titles. So there's a lot of cleanup that we're having to do when a loan has come out of a foreclosure, or property has come out of a foreclosure, even on the second, third, fourth transaction, because maybe the title exams and the prior examinations didn't go back 50 years and we find something that maybe they didn't see. Where it becomes even more convoluted is the type of loan that it is. So let's say that we have an open loan out there that is just a standard Fannie Mae, Freddie Mac first mortgage loan, where you have a fixed term for a fixed payment that is paid. It is not an equity line of credit. It's not a home equity line or anything of that nature where they can redraw. In those loans, most of those are pretty simple to be able to obtain clearance on, because we're able to find information on them.
Can you make your screen white again, please? It's hard to read. It's purple.
I don't, is that
Thank
why?
you.
Okay. So one of the issues that you're going to find is if it's a home equity line of credit, there's a lot more work that has to go into these because these don't expire for a much greater term of period. So let me back up and explain one of these pieces to you. On a primary mortgage, where it's a first mortgage loan where there's no redraw period off of it, as they pay it, it pays down the principal and it doesn't reaccrue additional principal because they're not able to redraw off of it. Those loans after the date of maturity are only good for 7 years on record. The Georgia statute allows for them to be dissipated, if you will, by law after 7 years. We can go forward and say, okay, nothing was refiled. We have the assumption under the statute that they were paid off and they were cleared. We still look for title clearance and we still look for a copy of the title policy for the prior owner so that we have that in case anything ever comes back. But those are pretty easy to clear up. The ones that are more difficult are your home equity lines of credit. With all of the mergers that went on during the downturn, we have a lot of lenders that did not properly clean up and release a lot of those home equity lines of credit that were sort of caught in the mix of the transfer over to the new lender. Those after the date of maturity, most of those are 10-year draw and either a 10 or 20-year repayment. So they're sometimes a 20-year loan or a 30-year maturity. The home equity lines of credit have a 20-year statutory period by which they are still valid until they are released. So those become a little bit harder to release unless we get a release from the prior company or the company that took over the servicing rights of that lender. One of the additional things that we're looking for are liens. When we're talking about liens, we're talking about a lot of the credit card debts, a lot of the liens against title of the property for the Department of Revenue. We're talking about liens against them for IRS. One of the most interesting liens I've ever had was a Department of Children's Services lien out of Louisiana. It was quite a lot of money, and they found out that the gentleman that had not been paying his child support was living here in Georgia and filed a very large lien against him here. They handle things with their child services repayment very differently than we do here. So that was those are some of the ones that we'll see. Also, we're looking for encroachments. We're looking for encroachments on the property from the neighbors. Now, one of the things that I think that you all need to understand is, and I say this in every sales meeting I go to that we talk about title, and every class that I teach, with encroachments, you have to understand I'm looking at what's on paper in the county. I'm not able to see what you guys have the benefit of seeing when you actually go and look at the property. So if you are traversing from a main road down a long, let's say just a sort of gravel driveway that appears to cross over other properties, you're going to want to look at the tax maps. And one of the indicators that we look at is to see if that tax map actually shows the driveway as being part of our parcel, or is our parcel stuck out in the middle of a field and it's just a square or rectangle parcel. And there doesn't appear to be a driveway that's being taxed as part of that parcel coming off of that to the main road. So those are some ways that you can look at to see if there is ingress or egress. One of the other ways that we look for encroachments is to determine if there's something been filed for an allowable encroachment for a fence. A driveway is often one of them, where we will have the parties have agreed to allow us to allowed a neighbor to leave a fence on the property without removing it. They just aren't making a claim to it. Homeowners associations and condominiums. We're constantly looking to see, is there an HOA? Is there a condominium? Is there something that we need to know about that will inhibit us from being able to sell without getting a letter? Or are there liens by that homeowners association and that condominium association that we need to know about? Civil proceedings, divorce. Now, I know that a lot of you do not understand why the divorce part of this can be very necessary for us. It all depends on what they're looking to obtain from that divorce. If there is a divorce, if there is a party that you're dealing with that is separated and they have not filed for divorce, they can agree to go in and sell the property without having to get a court order for that. However, once the civil proceeding for a divorce has been filed, we have to obtain from the attorneys acknowledgement that they are transferring title. And the reason that we want to do that part of it is because it allows us to be able to utilize that information to determine if there's going to be any type of alimony, if there's going to be child support, if there's going to be additional monies that are owed, who's entitled to the property. All of these things have to be taken into consideration. I have a lot of issue getting the divorce attorneys to respond to us in a timely manner on these. It's really incumbent upon you as the realtor to make sure that your sellers know when they're going through a divorce, and that we have to be in contact with the divorce attorneys, especially when there's not a settlement agreement in place. Now, if they have filed for divorce, the settlement agreement is in place, and they have an order that the divorce has been finalized, we literally will just look at the divorce decree and determine what the settlement agreement says, and we will rely on that. But even that gets complicated at times, because we'll have a husband or wife come to us and say, yes, but I ended up having to pay the mortgage for 3 months that we weren't planning on, and that wasn't part of the agreement. I need to be reimbursed for that. They agreed to reimburse me for that. All of those things take place. At our law firm, one of the big things that we constantly do, no matter what is going on, we always have, even if the divorce has been final for some time, if they have not or if they're asking us to do something that's beyond what the scope of their divorce decree and settlement agreement says, we will ask them to sign a settlement agreement between them and a split of divorce proceeds affidavit or agreement. The reason that we do that is not only just to protect our office, because with divorces it can be so complicated and so vitriol and so disputed, but also to protect the parties in the transaction, to make sure that this is really what they're agreeing to and that they understand it. I know many of you have emailed me in advance. I had a couple of you that emailed me a couple of questions because you knew I was going to be teaching this. And one of the questions that came up was about list pendens. This is where someone has filed a civil proceeding and they want to attach the title to the property to the court action that they have filed. So they'll file what's known as a list pendens. And what that means is we're going after their assets, including their property and whatever equity they have in that property. And as such, we don't want them to be able to sell it without talking to us first and us coming to some type of settlement on what we think they owe us. Sometimes that means if they haven't come to a settlement agreement, sometimes that means that we're going to put the money up in court, and sometimes that means that we hold it or that one of the attorneys in the dispute holds it. And then the other type of civil proceeding that we also often deal with is probate. Probate can be quite complicated. I see a lot of mistakes made by law firms with probate. There are a lot of situations in which we need an order to sell that is not obtained properly for closing. We see a lot of situations where heirs were not notified of a probate proceeding that we see that we have to go back and get them to re-notify. All of these things are done in an effort to protect the party so that this doesn't come back again later, and that we ensure that we're giving clear title. Now, some of the other miscellaneous title findings that we'll find is we often find a affidavit for contract, where parties have agreed to contract and sell a property, and somebody will sign an affidavit that, hey, I agreed to go under contract with this person, and then they backed out of the contract at the last minute and don't want to sell to me now. So we see some of those types of miscellaneous findings. And then we'll see affidavits that individuals have drawn up on their own come up. And then some other things that we'll find are UCCs. Now, why are UCCs important? Because that's typically a commercial transaction type thing. And why is it important to you for residential real estate? It is becoming increasingly important for you all. One of the big changes that I've noticed over the last 4 to 5 years is the change with the volume of UCCs we're seeing filed against an individual for work they've had done on their property. And one of the big ones is AC units, HVAC work. Where they're getting a new home HVAC and they don't want to pay the entire amount or can't afford to pay the entire amount to get an HVAC unit replaced, they'll file what's called a UCC. What this means to you is that they finance that work. So again, why is this important? If a UCC is filed, it's part of what I have to pay off at closing. So if they do a UCC against a property and it's for a fixture in that property, then we have to pay it off. And this often comes as a surprise to the consumer seller because they know that they have a monthly payment that they have to make on this. and they've been making their monthly payments on time, but they don't realize that a UCC has been filed, which basically holds up their closing, and that they have to pay that off as part of the transaction. Rent to own is still around. And for those of you that don't know it, rent to own often files UCCs on parties in the public records. I've seen them do it for everything from a washing machine to computers. If it's typically a personal asset like a computer, something along those lines, we can go to them and find out if it's been paid off. Many times it's been paid off and they just didn't release the UCC. But a lot of times it can be that there is an amount owed. Again, why is this important? Because it's coming from the seller proceeds. Because if you have back-to-back closings, they may have been expecting those proceeds to use for their next sale. And the amount of proceeds they're getting from this one is now decreased, and they weren't expecting that. So that's all part of what we're looking for. Our firm handles title exams a little bit differently than a lot of firms. I don't wait on your due diligence to expire, especially in this state right now where it's taking a little longer to get the title exams back because of the county closures right now. We order title whenever we receive your contract and go ahead and try to start working on it to determine whether or not there are issues. Sometimes we get notifications from the title examiner, this one's going to take a minute because we're finding something, or we've got to verify a whole bunch of properties in situations where you have potentially one person buys, a parcel of a 20 or 30 acre tract. We have to verify those lines match, and we're looking at that. So there's a lot that goes into this. Now, one of the new things that we are seeing a lot of, and it just is part of the nature of the industry of what we're working in right now, is we're seeing a lot of issues with the tax office not matching the legal description properly, or an issue potentially with the tax office maps. They are getting better at what they do, and they are getting better at being able to set out the boundary lines for properties, and sometimes they don't match. We had one recently that we've been working on that somewhere in the chain of title about 45 years ago, my seller owns it from his dad. His dad owned it since 1947, owned this property. And somewhere in the chain of title, the neighbor has taken over the driveway, although everybody has agreed that he is supposed to own the driveway. He's not been taxed on that driveway in almost 40 years because their legal description encumbered that driveway. So we had an issue that we had to go and fix. And the tax maps often help us be able to look at that. So let's look at what actually constitutes a title problem. And I'm going to try to raise this up for you guys. So let's talk about the title problems. It can become something from what we've talked about, which is a matter of record, or it can be title problems that potentially could be covered by title insurance, which, depending on the type of policy they bought, depends on whether or not it's covered by the title policy. So matters found of record are all of the things that we would find during the normal consummation of a title exam. I'm going to throw one more in here, and this is the one-off situations where you have someone that has what they believe is a vested interest in this property. Contact the law firm and tell them something is going on that we did not know of based on a title examination. And they're especially true when your buyers are not getting surveys. So we've had people call us and say, hey, I know that I gave the quitclaim deed over to her as part of our divorce, but I understand she's selling it and she never paid me the money that I was owed from it. And so these are things that we're constantly having to work through. One that we had recently was they were buying a property that abuts a small pond, and each of the owners own a little bit of the pond. The prior owner had agreed apparently to pay some funds for the repair of a dock. And they all agreed to do it as, a prorated share of the ownership of the property. And that wasn't done. So once we're notified of it, it's something that we have to at least investigate and look at and determine whether or not it is a valid claim against the title that we need to take care of, or if it's something that is really between them civilly that has nothing really to do with our property. So all types of title problems come up, all types of issues come up. One of the ones that I think is probably the most common misunderstood thing is that title insurance does not necessarily protect every defect that would occur if a buyer fails to buy a survey. And I know that is somewhat shocking to some of you because I hear it in my office all the time, but they have title insurance. Yes, they may have title insurance, but your title insurance may not protect against that defect without a survey. And even when there is a survey, there are often issues where there is a deductible, and there's also a lot of caps on the limit of liability that the title insurance companies will pay. I will tell you a couple of different things about title insurance. Basic title policy, it covers quite a bit of stuff, but one of the things that that you have to issue it for is raw lands. I cannot issue an enhanced or expanded title policy for raw land. So if they're buying just a piece of property, they're going to get a basic title policy. If they buy the enhanced or expanded title policy, it covers so much greater information, and I'll show you a chart here in a few moments on that, and it covers so many more claims than a basic title policy would cover. I'm going to try to open up a separate file here for you. Let's see, is this let's see which one is. And that way I can go over some of this. Okay. I apologize that this is a little bit, can you all see that? Okay, I think, yeah. So it needs to be within the box, right, Dana? It needs to be within that box. Okay. So one of the things, and I just wrote this out so that you guys can, if you want to capture the image on it, you can. Since 2000, most owners' title policies issued have been enhanced. There's coverage for additional matters that a survey would have shown, even if the buyer doesn't purchase a survey. Where this really came from is that the lender's title insurance policy protects the lender in the event that there is not a survey issued. So prior to 2000, survey coverage was only given if a survey was performed. Under the enhanced policy, any problem that a buyer is aware of may be accepted from coverage. And I want to give you my favorite example of this. We had a buyer who bought a property about 3 years ago. And during that transaction, it was disclosed to the buyer, unbeknownst to us, that they believed that the pool deck was over the property line. And fast forward 2 years, I get a notice from the title insurance company that says, hey, they've contacted us. They said that there was something that was missed during the title exam. And I look at the claim, and they're telling me that there's a pool deck issue that's encumbering the neighbor's property, and that we failed to issue a survey at closing. So one of the issues is, we don't issue surveys at closing. Those are up to the buyer to obtain a survey if they choose to do so. It's not mandatory, as you all know. But in talking to the realtor, what I found out, I called her and I said, hey, are you aware of this? Do you know anything about this? And she said, actually, the buyer was disclosed this during the transaction. And there were actually some emails went back and forth between the listing agent, the buyer's agent, and the buyer, that there was a potential that it went over the property line slightly, but they still chose not to do anything about it. And no one told our office this was going on, or we would have required a survey to be completed. So the way that they found out about it was the neighbor decided to sell their property, and that buyer obtained a survey. The pool deck wasn't just a little bit over, it was 18 feet over onto the neighbor's property. And once we knew that the buyer knew there was a potential, our owner knew that there was a potential, that is not going to be covered. So even if it's a non-disclosed, it's very similar to what's going on in the home warranty world right now, where you all are getting home warranties for repairs that are known. A lot of the home warranty companies are not covering those repairs because it was a known defect to the buyer, and they are deemed to have accepted the property as it is. So one of the things I hear often in closing is, well, we just, instead of doing the repairs, we gave them a home warranty, and they can call the home warranty company and get that covered. Many of the home warranty companies are now asking for a copy of what? The home inspection. So when there's a home inspection performed, a lot of times there are things that they're not going to cover because they feel as though, and the same similar thing applies here. One of the things I want to point out to you is if a survey is performed by the survey, are accepted from coverage. So if completed and it shows that there is a encroachment of a fence, if there is an outbuilding or dwelling from the neighbor that's encroaching onto their property, that is not going to be covered by the owner's title policy because it's a defect that they've known about. But here's my claim on that piece of it. I would rather know what I'm getting into and get it fixed before my purchase than have to deal with it on my own and potentially pay out the fees to correct it later on. As I've said, there are deductibles and there are maximum payout amounts. A lot of times it's a $5,000 deductible with $25,000 coverage. Some of the caps are lower than that. So the question often becomes is why buy a survey if it's going to be accepted if you're going to get owner's title policy? And again, it is usually better to know about the problem up front, because if it's a problem that pre-exists to the buyer, my philosophy on it is why have the buyer pay for it to clean it up? And the other big misnomer about title insurance is just because you buy title insurance doesn't mean you get to automatically close on your next transaction without any delays. I hear all the time, she purchased a title policy, or he purchased a title policy, or my client got a title policy when they bought the property. Great. But just because they got a title policy doesn't mean that it's going to be covered. And it also doesn't mean that we're going to allow them, or the title insurance company that's reinsuring the property is going to allow them to utilize that policy to just move forward. We're often having to get what's called indemnification letters from prior title insurance companies. And then during the heyday of the downturn of the market, a lot of title insurance companies merged with other companies. They went under. So there's a lot of coverage that we're trying to find out is even going to be covered by some of these policies. And we're having to go to the new company to see if they're going to cover and how that's going to take place and what that looks like. So just because you get title insurance doesn't mean you can move forward. This is one of the reasons I'm a big advocate of cleaning it up on the front end instead of dealing with it on the back end. This is just some information about the importance of a survey, and I'm going to try to
Amy, we have one question that says, what if the structure is not on the neighbor's property but goes past the setback allowed?
Okay, so under the rule, there is a 3-year statute of limitations on variances. So if the property is over 3 years old and the house goes over for example, the building line, and that building line setback is, say, I don't know, 30 feet, and the house clearly goes over the building line. If it's been less than 3 years, they most likely will have to go and get a variance to correct that. If it's been greater than 3 years, the title insurance companies will insure over that in most cases. Does that help? Is that what you're looking for?
Yes, thank you.
Okay. So on the importance of a survey, one of the biggest problems I have ever seen actually occurred over in Paulding County. One of my buyers opted to get a survey, and we get the survey, and I'm looking at it, and something really catches my eye, and it was a utility easement. And as I'm looking at it and I'm trying to figure it out, I pick up the phone and I call the surveyor, who I know quite well because he does quite a lot of surveys over in Paulding County. And I said to him, am I seeing what I think I'm seeing here? And he said, you are. He said, I started to call when I found out that you were the closing attorney and just give you a heads up on it. But it was a gas line, and the gas line ran right through the middle of the house. The house was actually built on top of the gas line easement. And when we did a little bit more research, they had the gas company come out to chart whether or not the gas line actually ran under the house, which, as you all know, you cannot build a house on top of a gas line. It did. So that was one of the things that the survey showed. Most often what the survey shows us is fence encroachments. We see a lot of fence encroachments. I get asked a lot of question about new construction. Well, it's new construction, I don't need it. Yes, they do. We see a lot of, just like the question was just asked, building line overage changes. We see a lot of changes with the scope of properties. We have a lot of builders who will build over a building line, and then they'll run out and change the plat and re-record it right before closing. And because there's a gap period between when we finalize the title exam and when we close, sometimes it gets covered in there, or sometimes they'll record it even after our closing, and we relied on the original plat, but they changed the property lines because they had a building line variance, and our buyer didn't know it and we didn't know it, and we have to go back and correct things when we find out about it. But we also see things beyond just the scope of the building line for the house. We will see neighbors have put fences on the subject property that we're selling. A lot of the little outbuildings, like the little sheds that people have, I know a lot of people like their she shed, as they call it, or he shed, as they're calling them now. We see a lot of those over the property lines, to the degree that we've actually seen houses built completely over the building line and the property line. We dealt with one of these in Smyrna a few years ago. The house was about 7 foot over the actual property line. And because it was a larger lot next door, they didn't realize they had built on top of their property, and that became an issue. One of the reasons that the lenders no longer require surveys is due to the fact that the lender's title insurance now insures over survey risk to the lender. Therefore, any problem that a survey would have shown is covered in the lender's policy. That is not true of an owner's title policy. I just want to stress that to you. The lender's policy does not protect the owners in any way. So there is no coverage afforded to a buyer because their lender obtained a survey, because their lender has title insurance coverage. Let me see if I can move this up for you. Often the buyer thinks that a survey would reveal problems that a title exam would reveal, or that the title exam should reveal problems that only a survey can show. As I was saying earlier, I'm looking at paper. I don't have the benefit of walking the property lines and seeing the properties that I'm closing. So I have no way of knowing if a fence is over a property line. I have no way of knowing a pool is over a property line. And even to that effect, I have no way of knowing when we're looking at title in the deed records room, unless there's an easement given or a secondary property that's attached to it from a main road to where this property maybe starts on some of the larger tracts of land. I have no way of knowing that there's actual easement for ingress and egress unless you show me that. So if you go out to a property and you're going down a fairly long road or a road and you're not sure if they own the access to the property, that's definitely a question you need to be asking. And if they don't, we need to find out if there's a survey. Believe it or not, we have a lot of properties that get closed in a landlocked position here in the state of Georgia, not realizing that there's not ingress egress. We look at the tax maps to try to determine this, but the best course of action we have is for you all to ask us the question and to show us what's going on with it when you're not sure. So one of the other examples is a title exam, for example, may show us that there's an existence of a sewer easement or a drainage easement, but it would not show that the easement runs directly through or beneath the house. We don't know that because I don't have the benefit of, when I look at a plat, of usually seeing the house on the property, because what is a plat? It's a pre-construction determination of how they're going to divide a tract of land. Whereas a survey that's recorded of record is going to show me how the property was situated with anything that was on the property at the time that this property was completed for that survey. So I'm a big advocate of getting surveys. I will tell you, for me personally, I will not buy a property without a survey. I won't do it. So if that gives you any credence as to what I see and how I handle them, I hope that helps you a little bit, maybe gives you a little bit more understanding of what we do. Okay, I'm going to go over this part with you, and I've got one more page to go over with you, and then I'm going to show you some differences between plats and surveys, and I'm going to go over some real life specific issues that I've seen on surveys. A plat is recorded in the land records. It shows lot lines and easements, and it shows all the subdivision lots. Sometimes the subdivision lots are 3. Or the plat will show where the builder has bought a tract of land and they're going to divide it into 3 properties, and they record it prior to the construction of the property. So it's not going to show me fences unless they're already pre-existing. It's not going to show me houses. It's going to show me what the intent of the property is supposed to look like as part of the rezoning process. Okay, this one gets approved by the commissioners. Usually it's approved by the commissioners, then immediately recorded into the county records once approved there. A survey is particular to a specific lot or group of lots, shows the placement of dwellings and other buildings in relation to the lot lines and easements, and shows driveways, fences, and other encroachments or improvements. So the survey is going to typically be much more in depth. We also have topographical surveys, which show us the elevation and the topography of the property. So we have elevation surveys as well. When is that important? When someone's trying to prove that their property is not part of a flood zone. So that's when it's really important to us to determine whether or not a flood elevation survey is necessary, is that we're trying to prove that the property, or at least the structure, is not part of a survey, not part of a flood zone. And then solutions for common survey problem violations. There's typically a 2-year statute of limitations, but the title companies are looking for 3 years in most cases. If it's destroyed, it has to be rebuilt within the property building lines because they never got the variance. So if they were over the building line, the property, the dwelling gets destroyed for some reason, they then have to go back and that sort of recalculates and restarts over. In some counties, pools and decks are not considered permanent structures, and the variance depends on the county. It's county by county. And as you know, if you're in the Atlanta metro area and you drive around, even within our sort of 12 metro Atlanta regions, you have counties that are very, very strict, like Cobb, on what their future use plan is and how they expect to use the property in the future in certain regions. Whereas there are counties, outside of the 12 metro county area, and even some of them inside, that there are areas that if you own the property and you can get it rezoned, they don't really care what you do with it. Fence driveway and landscape encroachments,
we've got a question, especially particular to a metro area such as Atlanta. The question, for example, Atlanta has an easement running through it. How would it be handled in a transfer of title with lots of, which I think you're getting ready to talk about now, the utility easements, sewer, underground utilities, so forth and so on?
Okay, I'm not sure I'm understanding the question. Are they asking, can you read that to me again? I think I missed a part of that.
Atlanta has an easement running through it. How would that be handled in transfer of title, seeing that a metro area has a lot of sewer and underground utility easements?
So when it comes to the sewer and underground utility easements, if we find them of record, they do go on the title policy. So the way that they're handled is, every single property that we handle just about has some form of easement on it, whether it's a utility easement, whether it's, for gas, power, sometimes it's a plumbing, line easement, sometimes it's drainage easements, sewer easements run through properties. So there's almost every property that we deal with has some form of easement that runs through it, especially if it's a developed property. So in those cases, we don't pay a ton of attention to a lot of these easements. If it's for utilities, if it's for gas, power, lights, all of that stuff. Where we do start to notice some of the easements is when they have a survey that sets out where that easement is supposed to be located. We look at those a little more extensively to determine, okay, does that look like where it's running? Does there look like there's an issue here? Especially with all of the underground use of utilities now, because a lot of the power companies are running the lines underground. Cable companies even are running theirs underground. So we see easements on those. Where we see a lot of issues in Atlanta are the properties that used to have the back alleyways for example, for trash pickup or for parking, where there's an alley between, the property on one side of the street and then on the street opposite of it or behind it. And then there's an alleyway running through there. We see a lot of issues with that, with parking in Atlanta in certain areas, and what they're supposed to have there. So I hope that answers your question. I hope that's what you were asking me. If not, send another email and I'll, or a message, and I'll try to re-answer that if that's not exactly what you're looking for. Dwelling improvements built over property lines. Okay, let me back up. Fence, driveway, landscape encroachments. Typically, there's an easy way to move those if they need to be moved, or we can do an easement for encroachment. One of the things that I want to point out to you is if they do a survey after closing, and I hear this all the time, I'm not going to get it right now, but I'm going to get it in a few months because I want to put a fence in. And so one of the big issues with that is they will then come back and say, hey, our survey revealed XYZ. And then we have to go in and try to fix an issue after the fact with a neighbor for an encroachment. One of the ones I see, the railroad ties or the landscape timbers that people use a lot in their landscaping. For some reason, those seem to be a big problem where they, are just trying to retain drainage or runoff. So those tend to be a big one. It's real easy to do an easement encroachment agreement if everybody's in agreement. I have one on my property right now. Our sweet neighbors, when we moved in, their fence was over on our property line and they have a dog. We didn't ask them to move the fence. We just did an easement agreement that they're not going to make a claim against the property. And if they ever take the fence down, they agree not to put it back on our property again. And it worked out fine and they won't make a claim against the title to the property. The dwelling improvements built over the property line. This is typically we'll get an easement for an encroachment, or there's forced removal coverage on some of the owner's title policy. For example, an enhanced policy has forced removal coverage. So if the county were to come in and it's not within that 2-year, potentially 3-year period, the county will come in and if they come in and say, no, you've got to move it, then there may be some forced removal protection there. Sewer water easements. Now, this is one of the ones that I do want to talk to you about. There's some court case law on this. And when you all see drainage easements off of the roads where the drainage goes between properties, most of you all would think that it's the county's responsibility to maintain those, correct? In a lot of areas, it is not. A lot of areas, it's the homeowner's responsibility to maintain those. And where we see this a lot is in the detention and retention ponds in subdivisions, where it really depends on whose land that retention or detention pond sits on and how the covenants and the plat was set up initially. In some subdivisions I've seen where there's a large subdivision that maybe has 4 or 5 retention or detention ponds, whatever they may have in those areas. Most of those lie within the confines of the common space of the homeowners association. But because a lot of builders have gotten very creative, if you will, in trying to get as many lots usable as they possibly can, they will often include one of those or more retention or detention ponds as part of the land that is owned by one or multiple parties that have land situated around it, and they'll include it as part of the ownership of the land of those that actually live around it. Those can be deemed to be the responsibility of the owner of the land, unless the plat or covenants say otherwise. And so I want you to, really sort of look at that if you're looking to buy a home or helping your client buy a home, and it looks like the detention or retention pond is actually part of the lot that your buyer is buying. We would need to look at the covenants and we would need to look at the plat to determine whose responsibility it is, and potentially get a letter from the homeowners association company to determine that your buyer isn't going to be responsible for maintaining that particular retention pond. Sometimes if it's a sewer easement that's running beneath a dwelling or improvements, they can move the pipe. They can show that it's an abandoned easement. They can fill it back in. There's a lot of things that can be done to fix those types of issues if we see those. Some of them are much more complicated than others to repair or fix, but there are options. So I just want to give you that, it's never a dead deal because you find these things. There are often a lot of ways that we can fix title issues. Those of you that have worked with me know I am very much an advocate of how do we get this to closing. It may take us a little time, but I need to get you closed and I want you to get the home. I want your buyers to get the home that they want, but we want to make sure they have clear title and we want to make sure that things are right. If your buyer's agent, if you are the buyer's agent and you've seen an old survey of the property, make sure you attach it to the contract with the offer. There may be things on there I see that you might not have noticed that I want to point out to you or that your attorney wants to point out to you. If not, the buyer waives after due diligence the right to get out of the contract because of material changes if a new survey is performed. So one of the things I want to point out to you is if you know your buyer wants to get a survey, even if they're on the fence, I want you to go ahead and put a special stipulation in your contracts that they want to get a survey or that the contract is contingent upon getting a survey completed at buyer's election. And that it be satisfactory to the buyer. And the reason I want you to do that is because we have seen a lot of situations where the buyers will call us and say, hey, my realtor said to call you and determine whether I really need a survey on this property. And I'm always going to tell them yes. I am always going to say get a survey. I never know what a property looks like until you see it. And I'm an advocate for making sure we know the problem beforehand. If they get a survey afterwards, they may not have a right to terminate the contract if it's not a true title issue and it's just something maybe they don't like on the property. So I want you to, if you think they may even do it, put it that it's at buyer's election. We're doing it contingent upon buyer's election to obtain a survey at any time during the process of this contract agreement, and that it's subject to buyer's approval or contingent upon buyer approving it satisfactory or to the satisfaction of the buyer. Make sure that you look at the old survey before making the offer to see if there are any problems that a buyer is not comfortable with. If you know they have a survey and they're saying in FMLS, you know, we have a survey provided upon contract, ask them to go ahead and send it to you. Go ahead and look at it. You may find things on there like an easement that you're not comfortable with. There may be a general easement, and one of the worst things that we see is a general easement that just says they have the right to traverse across property, but it doesn't set out where that easement's located. What that means to me is it can, I guess, be wherever the buyer sets it. Is that the way that it works? We don't know, because we don't have parameters that are well defined enough to know how it's going to work and who's responsible for it. Who's responsible for the maintenance of the survey? Again, I don't know. So if you see an easement going across the property, you should be thinking, who's responsible for it? Who's paying taxes on it? Is it a true easement, or did they sell it off? Where is it really located? Is it supposed to only traverse through this piece of it? What does the easement agreement look like? And who's responsible for maintenance of it? Survey costs run between $400 and $500 for a lot that's platted in a subdivision. I'm seeing this tick up a little bit. I'm starting to see them run more between $500 and $550 now. And of course, the bigger the property, the more it's going to be. And a survey accuracy has greatly improved over the last 5 years due to laser management measurements. They are getting extremely precise. I don't know whose phone is on, but if y'all could just turn that off, please. Is that y'all, or is that, okay, that's somebody's phone. Is everybody muted?
If you hover over manage participants, you'll see a button to click that says new call.
Okay, manage participants. Okay,
There you go.
does that work? Did that work?
That worked. I've got one generic question. There's a bunch of questions coming across the chat, but the nature of these questions is who's responsible for easement disclosures or encroachment disclosures? Is it a seller's responsibility to disclose, or is it a buyer's caveat emptor responsibility and due diligence? And a related question is, if what is there is an easement or encroachment that has been in place for over 20, 25 years, how, shoot, I forgot the term. When it's there forever, nobody objects to it. Does that?
Are you asking about adverse possession?
Yes, adverse possession. So those are two separate generic questions that have been scrolling through the chat.
Okay, ask me again, because I've got the adverse possession wrote down. What's the other one?
Okay. The other one is disclosure responsibilities when a buyer and a seller are negotiating for a property and there are easements or encroachments. Is it a seller's responsibility to disclose those, or is it a buyer's responsibility due to caveat emptor to investigate that information during their due diligence period?
Okay, it can be one or the other, and it can actually happen in both ways. So where I have seen an issue is where we have a lot of transactions where family has owned property and they've always just let the kids kind of use the property however they want to, and there's an easement and they don't mind the kids using that easement. But then when they have a new buyer come in, they want to make sure that they use a specific property. If that's the case, then it is incumbent upon the seller to disclose that information. My recommendation in those situations is to have a survey complete and set out where the new easement's going to be prior to listing the property. I think it's really important to get the property set up the way that they want to sell it before they ever list it. The other part of this is when there is adverse possession. That gets a little bit tricky, because one of the things you have to prove with adverse possession is actual knowledge and constructive knowledge of the person who is being taken from. So if something's being taken from you, you have to have actual knowledge of it. So just because something's been there for more than 7 years on an improved property does not necessarily mean that they've met all of the requirements in order to be able to claim adverse possession. And where we often see this is driveways. We typically clean those up with driveway encroachment agreements, things like that. We rarely have situations where a true adverse possession that I see with what I do actually takes place. So I don't have a ton of opportunity to use adverse possession because most often one of the parties didn't know, or the other party didn't perform one of the requirements that they need to meet in order to have adverse possession. It's a pretty extensive rule. So they basically have to. It's almost just short of basically notifying the other party that I'm going to take something. Now, they don't have to go to that extent, but it has to be something that's fairly overt. It has to be a fairly overt action. If they go in and fence in a property and they fence it in over the property line, you're probably going to be able to get adverse possession after a period of time, whatever that is, depending on the type of property it is, 7 or 20 years. If they have not fenced it in, one of the issues that we see a lot in some of these counties is where a neighbor has had a survey done. And we just dealt with one recently where when I talked to the surveyor from about 12 years ago, he said, no, I have notes here. They were looking to buy that piece of property and had me survey it. Well, the neighbor went in and recorded the survey, and they had never bought the property from the property that we were dealing with. They had never bought that property from them, but they did record the survey saying that they were taking over that piece of property. They never changed the deed work, never changed the title, but what happened in the tax office was the tax office changed the way that they assessed the property for taxes and started taxing the neighbor that wanted that piece for that property without the other buyer's possession approval. And one of the things that we look at is who's paying taxes on property. So sometimes that gets into a convoluted situation. So can you get adverse possession in certain cases? Yes. Is it easy? No. It's a pretty overt action and intention of taking is what adverse possession is. I often have people come to me and say, well, this has been here 10 years. Well, did the other person know that you had done this? Did you fence it in? What did you do? And sometimes they don't meet the threshold of getting adverse possession. I will tell you, I'm a big advocate when dealing with your neighbors that you get more bees with honey, because you're going to have to live next to these people for a very long time. And most people are fairly amenable to doing encroachment agreements, or at least some type of new boundary line agreement where they establish where the new boundary line is going to be that they're both fine with. So we do a lot of those types of title cleanup, types of work to clean up titles. I'm going to get out of this one here, and I believe it's this one. Yes, okay. I don't know how much of this you're going to be able to see, so I am going to do the best I can because the screen that it allows me to show is quite small compared to what my screen is. So I'm going to show you as best I can on some of this. There are a couple of things that I want to show you and point out to you and share with you on here that I think are really, really important things that you might want to look at. One of the big things right here is on this lot, and I'm going to do this with the scroll of my arrow here just to try to help you. If you look here, there is a 10-foot drainage easement right here, and that runs through the property. Now, why is this important on this particular plat? It's important because I need to know where the structure was actually built and to make sure that the structure wasn't actually on that drainage easement, because that could be an issue for the stability of the structure. And if you look at it, it's set kind of an awkward pattern and in an awkward way. So it might lead me to look at this and say, you know, I really think that I probably need to get a survey just to make sure that my property isn't on that. So I want you to see why we're looking at drainage easements and why we're looking at those. Now, this drainage easement over here is probably not very significant because you have all this other lot here that was available for building, and there's a very unlikely chance that they would have built something over here. You can look at this plat though and go out on the property and you would be able to say, wait a minute, they've got something in this very back corner here. I need to see what that is, or does it affect it? Or you might come to this piece of parcel and look at it and say, you know what, the property is built really, really close to the neighboring property, so I don't believe that that is the case. But the only way to know that for sure is through a survey, correct? So that is one of the things that we're going to look at. Now, this one is a little bit different, and you're not going to be able to read much of the writing on this one, and that's okay because I've got it here and I can show you what it is. There are a lot of things going on with this survey, and I'm going to point each of these out for you. Right here if you look right here and you see this little dotted line with the X's here, that is the neighbor's fence comes over our property. And what this is telling me is where it comes over the property and the dimensions of it. So the neighbor's fence comes over the property right here. One of the other things that I see on this survey, if you look at it, is right here. This right here says 100 BL. That's a 100-foot building line. What does that show you? That the property itself, the structure itself, is well over the 100-foot required building line for this property. So there are a couple of different things that are going on with this one that we would look at on the survey and say, okay, these are things that we need to address. When was the property constructed? How long has it been situated there? Is the fence still there? What do we need to do about that? So there's things that we're looking at there to determine whether or not that is affected and what we need to do to fix those issues. On this one, there's a couple of different things here too. You have the drive here. If you look, do you see right here on this corner? This is our parcel's driveway. I'm going to try to shift that up for you. This is the driveway for our property right here. And it goes over the neighbor's property line right there. Do y'all see that? It's about 4 foot, it says 4.1 feet over the neighbor's property line. But then I'm also looking here, and the front of the structure is over the 40-foot building line. So these are things that I'm going to be looking at to determine, are these things that we need to address? Are we beyond the statute of limitations for the change of this piece? And is there an encroachment agreement already in place? And if not, we're probably going to want to get an encroachment agreement in place for this parcel, even though it's going on to the neighbor's parcel, because I don't want the neighbor to come to my buyer and say, hey, you got to move that. And we want that removed, and it costs the buyer money to remove part of their driveway off of the neighbor's parcel. Let's look at the next one. Okay, let's see here. There's a couple of, okay, that's that one. Sorry, I'm trying to look at the computer and look at my notes on the different surveys to try to show you what we're looking at here. Okay, let's see here. Right here, if you can see this, this is the property line that goes right through here. This is the house, and it goes over the property line. Do y'all see that? I hope you can see that fairly well. But the house actually goes over the property line here, and this is what it's showing me. And then I have a frame building here. And then I'm also showing that the building, there's a piece of it here that goes over the building line, over the property line as well. So we're trying to figure out, in this case, okay, what was the time length of construction, where it's located? And then over here, is this something that's a frame building that is like a storage shed that can be easily moved? What is it, and what do we need to do with it? So these are all issues that we're looking at for that one. And I have quite a few of these to go through with you, because I just want you to become familiar enough with it that you look at it and can see it. Now, here is, none of this right here is a problem right here, but what I want to show you is this shaded area. I tried to shade it in for you to make it more visible. This is the neighbor's property. This is their asphalt driveway is over 6.1 feet, 5.9, 3.3 feet here. If you look at that, their driveway goes significantly over. And this is why I tell you, with new construction, it's often very, very, very important to get a survey, because I want you to know what these issues are beforehand. A lot of times the surveyors, contractors just make a mistake and build over, or they're not paying attention to something, and or they think they've got it shown properly and it's not. And then the other part of this I want to show you right here is the fence. In this one, we couldn't make a determination of who the fence belonged to, so we had to ask the parties who the fence belonged to right here, because I didn't know if it was part of theirs and they fenced in and did it here because of their driveway, or was it their fence and they just fenced in something here for privacy. We weren't sure what was going on there, so we had to ask the parties about that. The next one, okay, let's see here, is this one. Okay, there's a lot listed here, correct? Can y'all see all this all these lines? So I want to show you, where's it at? Up here at the top. It's here. This is not turned the same way. This is our asphalt parking right here for this building. This is our asphalt driveway. And it actually shows, I don't know if you can see that or not, 7.8 feet over. So it's about 8 foot over the property line. And then we have also right here, what that says is that the eave of the property, the eave of the structure goes over the property line there as well. Then over here, you have a carport and a frame shed that are also over the property line. So this owner really just didn't care where their property lines were. They were just going to put stuff wherever they felt like doing it. And they just, were going to do what they wanted to do. And apparently nobody complained because they got it done. But all of these things are over the property lines. Here's the interesting aspect of this. I now have to find out who owns this property, and I have to know who owns the property over here too. So I'm not dealing with just one potential neighbor. I'm now dealing with two potential neighbors that I have to deal with to make sure that these are correct and that this is shown properly. On this one, the neighbor's concrete driveway is over here. And it's extended onto our particular property. And then we have on the back side, I was looking at that note, trying to look at here. And then this line, what our survey pointed out right here, I don't know if you can see that, but we see this often where a recorded plat for a neighborhood is wrong. And our surveyor set out here that this line in, what it actually says is this line in error on recorded plat. The way that they showed the line on the recorded plat is not correct, and we have to go back and look at that and maybe do some corrective work with some neighbors to figure out where that line is supposed to be, because what they've done is they've taken where the pins are and there's a measurement that's wrong. There is a neighborhood that we recently dealt with over the last 4 or 5 years that we helped them get it corrected, where it is fee simple townhomes. They don't just own the land, the structure. They actually are supposed to own the land that their structure sits on for the townhouse here in Cobb County. And there are absolutely no measurements. So if you'll look back here on this one, see how there's measurements all around each line so that we can see how big each lot is. There are no measurements at all on the entire recorded plat. And the properties have changed hands multiple times over the years, and I don't know why it wasn't caught or brought to their attention. For whatever reason, it was not. And we found it, and of course took it back and started working on it to get it corrected so that we could look at it and see what we needed to do to make sure that our clients were protected on that. And I'm sorry that it's going to purple. I am trying to scroll this down for you. Okay, on the next one here, this one is, and I'm sorry these are all turned weird. I can't turn the screen with the Zoom feature on, and I didn't realize I couldn't do that. I can, actually maybe I can, let's see here. Okay, yeah, so that actually works. Okay, so that's letting me do it. Okay, there's quite a bit that we're looking at here. You have a framed house right here. What this is showing me, do y'all see this line right here? This is where the flood line is per the FEMA map. Okay, this is showing me the flood elevation right here on the field location. So this is showing me what is in a flood zone and what isn't. And these are the elevation numbers right here. And then here's the building line. So you have to sort of know what you're looking at here. But what's interesting is that it runs right directly in between the middle of this property. So this house is most likely, and I don't know of any lenders that wouldn't, going to require flood insurance. If you've ever dealt with flood insurance, it can be quite expensive. If you're unaware of that, it can be expensive. Okay, so the next one here, and again, I apologize, guys, just bear with me while I'm flipping these around so that you can see them a little bit better now that I have figured out how to do that. My kids are much better at this than I am. I have realized in this age of online classes for my children, they are much smarter little beings than we maybe gave them credit for when it came to this type of stuff. Another flood zone one here, see the line right here? This is the 100-year floodplain scaled from the firm maps, which are the maps that are recorded at the county. And then here, one other thing that I noticed on here, can you see this right here on the front end right here? There is some easement. There's a storm drain that is there, and the back of the property is actually sitting on top of that. So there is some concern, there would be some concern as to the viability of the structure sitting on top of an open hole is basically what we would be concerned about. Would that cause it to collapse? Is there a risk there? What are we looking at here? So all of these things are things that I want you to know exist so that you know I'm not asking when you leave this class for you to be an expert in surveys. I would like for you to be able to look at a survey and kind of know what you're looking at a little bit so that you could come back to me and say, hey, look, I'm not sure what I'm looking at here. Can you look at it? I would recommend whatever closing attorney that you work for, that you send these over to them and ask them to review them and let you know if there's an issue. I welcome to look at surveys because it gives me a lot better picture of the property that I'm closing. I never mind doing that. So if you have surveys that you're concerned about, certainly send them over. Have communications with the surveyor, find out what they thought, ask them if they saw problems that maybe you don't understand or you're not seeing, so that you can look at those and see, if there's something that you need to look at there. The next one that we have, I hope this is helping y'all be able to look at some of these and see what we see on a regular basis. Okay, let's see here. Okay, do y'all see here that the fence is over the property line? So it's always going to be a line, sort of a dashed line with X's on it that always indicates a fence. But look here, the drainage easement. Do y'all see where it runs? Right below the property. So this happens way more than you all, I think, realize as realtors that it could happen. I'm a big advocate for those of you that are brokers that you still have them sign off on. You told them of the importance of title insurance and surveys, and they chose not to get it. For those of you that are not brokers but are realtors, and agents, it protects you too. And a lot of what we do is an opportunity to protect you from any claim, because just because you say it verbally, we say this all the time, when you say something verbally, unless it's recorded, you can't prove it. You can go back to your broker 100 times and say, I told them this. I know I told them this because I do it on every single one of my transactions. But unless you have it in writing, you can't prove it. The other thing is if you get a very convoluted survey and you're really not sure what it says, I would recommend that you give it to the buyer and tell them, please have this reviewed with your attorney or have the surveyor review it with you. There's a lot on it. I'm not sure what you need to look at and what's important to you, and have them do that, but follow it up in writing that you told them to do that. Okay, on this one, and I've tried to redact out the street names, although a lot of these are recorded, just because I've seen these over the years. I still try to redact out the street names. So when you see the black lines, it's just me trying to redact out some of the information. Okay. On this one, I want you to pay close attention to right here, and I'm going to flip that around for you. Well, I think it was better the other way. Let's try this. Okay, one time. Okay, there we go. All right, so all this LLL is land lot line. So every county is broken up into certain sections for title property. In the Metro Atlanta area, we go by land lots in districts. In more of the rural area, they go by what's called GMD, which is General Militia District. So you'll see that sometimes. It's basically, how the county divides out the property into sections for real property title work. Right here, I want you to look, there's a couple of different things going on here. You can see that the property here, the frame of the house is actually over. The wood deck is over. The line here, and then you also can see that here is where it's supposed to be. And then this is a fence, it looks like, right? Yes. And so this is a easement here for the drainage. And so anytime you have a house that's over it, we would need to get the surveyor or even sometimes the counties have to get involved and determine that the drain itself maybe doesn't come under the corner of that house. Determine that there's no potential structure issue that could come up later on. Okay, let's look at the next thing. And I have just a couple more of these and we'll get out of the survey so that we can move on to something else. Let's see here. I'm going to turn, okay. So this is the storm drain and drainage easements here. You can see where the property is, or where the dwelling is actually located. But here's what's interesting. If you look at this property here from the front of the road, there's a 50-foot building line. They did great on that. There's a wood bridge that goes over. There's a footbridge that goes over. There's a creek that goes right through the front, okay? And then here's the easement here. So in order for them to utilize this property, for the builder to be able to utilize it, they had to put it behind the creek bed, because otherwise they would have been in front of the building line here. But then they stuck it on top of this. And again, we're going to be checking to see what is this, what's really there, who do we need to call to find out, is this really an issue for the property, or is it not really being utilized? And if it's not being utilized, who has a right to it, and what's it being utilized for? And then here, I know that you can't see some of these on here because they're written really tiny. Most of the newer ones are done by typing, and we don't have to worry about them printing them on there and seeing them looking like this. But some of them are still done this way. I'm going to try to show as much of this as you can. If you look up here, you see that this is the Chattahoochee River right here. There's a buffer line that's required. If you deal with properties on Allatoona or Lake Lanier, you will often see these buffer lines of what the buffer lines show for the properties that are located around the lakes. This 60 foot right here says permanent easement. Okay, right here, that's permanent. That's not a temporary. And they just set it out. And then this is just impervious, what they called impervious improvement setback line. So if they were going to put a shed, something like that, this was the setback line for there. This piece, as I'm scroll down a little bit, this is the 100-year floodplain right here. So from the Chattahoochee River to here is where the 100-year floodplain shows, right there. And then here's my dwelling. I don't know if y'all can see what that line is, but that is a utility line that runs, some type of utility line that runs up under our property right here. So we would have to investigate that to determine what the issue there was and what it's being utilized for, and if there's a way to move it, to set it back to another location. Potentially what they'll do is they'll take them around a lot of times and then try to fill that in if there's a house that's been sitting there. It can be quite costly, as you can imagine, to do that type of work. Again, another house built on a drainage, I'm at a easement right here for sewer easement there. Floodplain is shown here, as you can see there, and here, right there. And then here, another creek bed. So we have a creek bed here. But then here we have a 35-foot building line, and they're just inside of that. Sidewalks for the property and concrete driveways are not affected by the setback lines. Those are not included as part of the setback lines. And then right here, what this is telling you is there's some type of landscape, possibly retention walls that are here, and those are on the other side of the property line. So these actually come over 0.4 feet. So I know it's a very tiny amount, but it is an encumbrance upon the neighboring property. And these are some of the things that we're constantly looking at and reviewing for you guys. Here's another pool deck. Do y'all see that? The pool deck is over the setback line there. And then here, and this is, I think, the last one for you guys. I think it's the last one. And then on this one, let's see here. I think the pool is over, if that's what that is. Yeah, so the pool is over not only the property line, but it's also over the setback line on there. And then we also have a fence. This is the fence to our property based on the surveyor's conversations with this owner. This is the fence to the property we were looking at selling, and you can see how far over the property line that is. And then this is the pool area there. Okay. And then on this one is a newer survey that we look at. Doesn't show anything much different than some of the other stuff that we have shown you previously on here, other than I do want to point out just a few little things. Right here, the surveys have gotten so good. See, this is a 15-foot building line. It shows you that it's 15.2 feet. So barely meets inside that 15-foot building line, but all we really care about is that it is. There is a gap here, as you can see, that it's between that and the building line, and they're very close. This is over. The wood steps are over the building line, and then this right here is showing that that's over. And it would really depend on, it's some type of retention wall, is what it shows, and we can read that up here in this area, is that it shows that it's a retention wall. And it really depends on what type of what the setback rules are and whether they are allowed to build small structures or retention structures within those, or whether they are not. Okay, does that help y'all look at some of these surveys and see what we're coming up against when we review them? And then let's see here. Okay. Revert. Okay, because I had changed those around. Okay, so Dana, is it time for a break before I started on the next stuff, since we? Okay.
Amy and I will both stay on to answer any questions that you have. I'm going to leave this slide up just for a little bit, and then I'll put it back on us. But we can still hear you, even though what you're seeing, hopefully seeing, is break. Be back at 11:19.
Okay, thank you.
You're welcome.
I'm sorry. Hi, Miss Amy. This is Nisha. How are you?
Hey, Nisha. I'm good. How are you?
Good. Thanks for staying safe and doing this class. Very informative.
Oh, good. I'm glad. Good.
I had a question about a survey.
Yes, ma'am.
Actually, it's mine. When we figured out, when I signed up for the class, I made sure that I got my survey out from my purchasing a home. And I have a neighbor behind me who always thinks that my person that cuts my grass is supposed to cut her grass. He moved the stakes several times, and he's actually cutting the grass now. And I went out there and I seen her in the back saying, you know, waving him to come cut her yard. And I'm like, no, that's not my property. So my question to you is, I put up in the chat, when you put a fence up, because I'm gonna have to clearly put a fence up, would you recommend me going to the stakes where the survey is, or a few feet before the stakes, or how would you recommend me to put up a fence? Because clearly there needs to be one.
Absolutely. Okay, so there's a couple of things you need to take into consideration. A lot of subdivisions have rules that the fences have to be on the property lines. And the reason that they do that, I think it's Bentwater or either Seven Hills, or maybe both of them do this. The reason that they do that is they don't want that gap in between one neighbor's property to the other's neighbor's property, because they don't like the aesthetic look of that.
Right.
Logically speaking, when you put it on the property line, you both own each side of the fence.
Right.
So we have had neighbors who have gotten very angry because another neighbor has put up a fence and they didn't like it. So they started drilling holes to put planters in and doing some not so nice things. Again, I'm an advocate. Be nice to your neighbors, people. You never know when you're going to need them.
Right.
I typically would say if you move with, even a foot inside of your property line, then the fence is really yours. But you really need to look at your association rules, if you have them, and covenants, and see what they say. Most of the newer ones require that you put them on the property line. If you're going to put it inside the property line, that's fine. You just need to understand that
I need to go outside and mow that.
Yeah, I mean, it's still your responsibility. It's still part of your lot. If you're going to put up a fence just because you have a landscape issue, that's a whole nother matter. But if you want to put up a fence just to avoid the problem, check your covenants, check with your HOA. Obviously, check with your HOA on the type of fence that you're looking to put up, if you have covenants, because a lot of them are very strict on the type of fences that they'll allow. Does that help?
Yeah, I want to talk to her, but with the COVID-19, I don't want to, and she was out there with her mask, and I'm trying to be as pleasant as possible, because I just literally lost my brother.
I'm sorry to hear that.
And I inherited 2 kids, a 10-month-old and a 5-year-old. So I don't want any confusion. I got enough going on right now.
Yes, ma'am.
It's very informative. So I'm gonna try when the COVID kind of settles down, and maybe the next time he mows the lawn and she comes out, I can go show her my survey and say, hey, that's not my property. Can we come to some type of agreement? Because I'm not gonna pay for him to cut your lawn.
Right.
So But I
Um,
asked that question.
Right. Well, and I think you're doing the right thing. First of all, I'm very sorry for your loss. And secondly, certainly commend you for taking his children. I know that's a hard step, and I know that's a big change and adjustment. I can only imagine how tough that really is for you. I think that you're right in waiting. Just during this time, you have a lot going on. I think it will come across a little bit better once all of this is over, and especially with the opportunity to be able to move beyond it, in a month or so to be able to handle what you need to handle. If you have questions later on, or if you have copies of your covenants, or have some concerns that come up with your HOA afterwards and you're not sure about, just reach out to me. My information's on that first screen, and we'll put it out again. I'll make sure that you all have my email and my phone number to reach me, but I'm happy to look over the covenants and help you if you need help with that. Okay?
Thank you so much.
You're so
Nisha,
welcome.
you are getting lots and lots
Okay, Amy.
coming through on the chat.
Amy.
Yes, ma'am.
Okay, Amy. In question to that fence you just mentioned, when you said once it goes on the property line, now you both own the fence.
Mm-hmm. Yes, because
So-
here's the issue. If it's on the property line, neither one of you technically own the line. So you own your side of the line. It's a very narrow strip. So if you put a fence that's on a property line and part of it's on your side and part of it's on their side, the technicality of it is that a piece of that fence is really on their side too. Correct?
Yes. Now I've dealt with that in the past, and now I'm getting ready to have a fence put in because we're in another home now. But here's my question: when in the past, when our neighbor put it up, she put it on the property line, and she came to me because I built off of her fence, and I came up to 1 inch of that fence without touching that fence. And
Okay.
she comes and she knocks on my door and she go, you're going to have to move that fence because if my dogs dig, they're trapped in your yard. Well, I went through the whole counting thing, and we went through this thing with the building up too. So I have another neighbor now that has done that. So what we're getting ready to do, we're getting ready to put in a fence on our side. So
Okay.
with building up to 1 inch of that fence, is that something that is, because I talked to the county there, but I didn't get anything in writing. Is there something out there somewhere that I can find if that becomes an issue that shows, okay, that fence is on the property line, you own that side, now I own this side, but I built up to 1 inch of that fence?
If you build up to 1 inch of that fence, it's on your property line. Bottom line, it's on your property line. It's on
Okay.
your property. The one thing I would say is that fence companies are not the best at following surveys. I would be very cautious to make sure that you have your survey out there. If you're really, really, really concerned about it because you think you're going to have a problem, you might want to have your surveyor stop by and draw. Some of them will set out the stakes for you and flag them. I would recommend that you do that so that it's very apparent and all of that. Now, I see some things coming up saying that it has to be 6 inches from the property line. It does not necessarily have to be 6 inches from the property line. That is a rule of thumb that it has to be, because there's can be quite a bit of confusion. That is what a lot of counties will tell you, is that it needs to be 6 inches from the property line. But there's no hard and fast rule for that. If it's on your property line, it's on your property line, and there's some case law to back some of that up. So it really depends on your municipality. If any of y'all want to look at your county codes for some of this, there's a thing called Municode, which I'll put out here for you. You can go in there and look at the code section for everything that goes on in your county, all the way to whether or not they can file liens against unpaid water bills in your county. So I will put that out for y'all. You just have to go to Municode. You go and you put information on there regarding the county that you're looking for, and then you can type in like a little search and you can look for it and see if there's some things on here, especially with regard to surveys and pools and fences that can be used. Cobb County has a fence height requirement. You can't build over a certain height of fence from the ground up. It has to be below a certain height. So each one of them have their own thing. Does that help?
That does. I just wanted to make sure we didn't go through the same thing we went through with the other lady when she was like, well, you can't build off my fence. And it's like, well, it's on the property line, and my fence post is actually on my line, which is 1 inch from your fence on the property line. Okay.
As long as it's on your property line, and you can actually have the surveyor come back out. We had to do this in one of property that a family member owned. We had the surveyor come back out and run, show where the stakes were, and we were able to run just a twine line from one stake to the other and show that the fence was actually inside the line. So that will be able to help. So there's a lot of things that can go on with this. I'm trying to move this up, Dana, so that I can see, if you don't mind. Trying to move the chat up.
There's a little teeny tiny dot at the very, very far right. And if you put your mouse on that, you can push it up and scroll through the previous comments. Do you see that?
No, I don't. I'm not seeing that.
Okay, do you see where it says Zoom chat?
Let's see if I can do it this way. Okay, I found something. There we go. I'm just trying to get through all of the questions. Try hitting all if the chat button isn't. Okay, let's see here. A lot of y'all are putting your name, email address, and license number, which is great. Trying to just scroll through some of these just to see if there are questions that I can try to answer on some of the things that you were asking about.
So Amy, where you see their names and stuff scrolling at the very far tippy far right of that, you'll see it's really skinny, like an 1/8 of an inch or less, a 1/16 of an inch. You'll see a little teeny tiny grayed out dot. If you put your mouse on that, you can push that up and scroll through the actual chat.
Okay.
A lot of the questions, there was a question about the verbiage for the special stipulation that you mentioned earlier, and there have been a lot of questions about new construction. And
we get a lot of new construction questions, yes. Okay, so the special stip, are we talking about the special stip that I mentioned earlier about special stipping the survey? Is that what you're talking about, the need for a survey?
I believe there was that special stip, and there was something towards the beginning of class. And again, I would have to scroll through also. We do save the chat.
Okay.
Get a copy of that. And for you guys on the class, I will, once everybody gets back, I'll give you a link where you can access the information for this class. We are recording it, so I should put the recording up. And then any verbiage that Amy gives me, I will attach as a PDF handout that you guys can also have. You guys feel free to type your questions, and I do have the microphones unmuted for now till we start back in a couple of minutes.
And don't take your cameras with you to the bathrooms. I don't know if y'all have seen all of that going on. There's been some really interesting things shown on some of these videos lately. Okay, I am, let's see here. I am going to write out the survey. There is a GAR special stip and an RE special stip already out there. If your buyer wants a survey, I will type this up really quick while I'm talking to Dana and shoot it over to her, or while I'm talking, I'll shoot it over to Dana for you, or we'll do it afterwards even, and follow up afterwards when you get your confirmation with a copy of that survey language. Is that good, Dana?
That will be great.
Okay, I will do that.
Do you have a number for that special stip, an F number for the?
Honestly, they've all changed so much over the last 2 years. All the documents have changed. Their numbers have changed. I have not kept up with the numbers as well. I can go through the GAR special steps and look for it for you, and we can put that out for you as well.
All right, thank you.
Yeah, no problem. All right, any other questions about that part so far?
I don't see any, Amy, right now.
Okay, no worries.
You guys are doing awesome. We have over 396 students on this CE class.
Woo! Wow, that is crazy.
I didn't tell you that beforehand, Amy.
Oh, that makes me a little more nervous now. Okay, so are we ready to start back? Is it time, or they've got another minute or two? Okay.
It's time.
When you guys come back in, please type in, as you see people doing, your name, email address, and real estate license number. We want to make sure everybody gets credit.
Hey, Amy, can I ask you a question real quick?
Sure, yes, absolutely. Who am I speaking to?
I typed it in the notes. I don't know because I got dropped off. I sell a lot in the city, like condos, townhomes, that sort of thing. Surveys. Do you recommend surveys for those type structures?
I do. Okay, so for condos, okay, there's a difference between when you're looking at a townhome versus a condo. So let me go through and explain a little bit about that for you. Am I muted, Dana, or am I good?
Yes. You're good.
Okay, because I got a little mute symbol that just came up. with a condo, they don't actually own the land. So there's really nothing to survey with the condo. They literally own the interior walls of the unit. With some townhomes that are the, 1 and 2 story structures that are side by side that have attached walls, they can be deemed to where they can be zoned as a condo style townhome where they only own the interior walls, or they can be fee simple townhomes where they actually own the strip of land in front of and back of their property, or even just the property that their unit sits on. The only time that, and this is one of the things I would say to you, is when you're dealing with fee simple townhomes and you're dealing with back patios and where maybe the prior owner built a structure, something like that, because we've seen that a couple of times, and the structure goes over into the HOA common area behind the property. A lot of the fee simple townhomes maybe have like a walkway where everybody can walk around the area behind there, and we've seen some of that encroachment type thing, but that's typically brought up by somebody with the homeowners association. If you're dealing with condos, no. I mean, because you're really only looking at the interior of the unit. That's what you're looking at. So I don't see a need for that. I will say to you, when you're dealing with condos, the one thing I would ask and make sure you're on top of on the front end, because we've seen a lot of problems with this, is the issue with whether or not the water bill is being paid by the condo association, or if they pay for it separately. We've seen a lot of issues with water bill liens or large amounts of unpaid water bills for those types of associations. So that's something to certainly look for.
Okay, I'm sorry, I got cut off. My Wi-Fi dropped. So did you hear my question?
Whether or not you need them for a condo?
Yeah, condos and townhomes.
No, you don't need them for the condo. The differential between townhome is you need to know whether it's a fee simple townhome where they are owning a townhome where they actually own part of the land, or if it's a condo style townhome where they don't own any of the land and only own the interior. If they only own the interior, there's nothing to survey.
Got it. Okay. Thank you very much.
You're so welcome. Okay, I guess, Dana, are we ready to start back now?
We are ready to start back. I'm going to mute everybody. Welcome back from the break. Thank you, Amy Davis of Davis and Associates. Amy's email address. You want me to give out your email address, Amy?
Yeah, I put it on the chat too.
Okay, it's adavis@davislawga.com. And at the end of the class, I'm going to put up that beginning welcome screen again. You'll have Amy's email address. You will also have the email address of Heidi Kelly, who is the coordinator of the Georgia Real Estate Academy. She is the one recording the CE credits with GREC. There are a lot of you guys on, and there's a lot of reports that we have to amalgamate to get to put together a roster. It takes 3 to 5 business days for us to record the CE credits. But I'll pop up that screen at the end of the class. But I'm going to mute everyone. And Amy, I'm going to give you the hosting duties back. I thank you guys so much. This is, I think, the wave of the future, definitely for at least the near future. And I thank you guys so much for attending. And Amy, fabulous information. With so many people on, the chat is scrolling really quickly, but tons and tons and tons of great compliments and great questions. And I also appreciate some of you guys interacting with yourself about things you have knowledge of with specific pricing and things like that. So thank you guys so much. All right, Amy, I'm going to mute everyone, and then I am going to give you the host. All right, you're muted. You have to unmute yourself.
I'm going as quick as I can. I am definitely not as savvy about this as my children are. I was practicing on this last night, and one of my kids, who's a 6th grader, told me, she said, "Mom, no, it's this way." And I'm, of course, looking at her like, how do you know this and I don't? Okay, so let me go ahead and start here for you guys. Can y'all see the screen, and is everybody good on the screen right now? Okay, so I want to go over the next half of this is just a lot of the pitfalls that we see and a lot of the strange, but and often unique questions that I see, but often the questions that you guys ask me that are actually not very unique at all that I get a lot. I want to talk to y'all about these right here. And I know that this is a little bit different of a format. It's different for me as well. And I am trying to interact with you guys on this as much as possible. I am a very face-to-face kind of worker. I cannot wait for the day for y'all to be back in closings, if you want to know the truth. I am very excited for y'all to come back to closing. It's very different when you're not there. And you actually provide such a great service by being there when you are at closing, because your clients are more comfortable and they understand a little bit better and have you to rely on to sort of guide them through that process as well. So this is unique and different. I do actually like it. I think it's actually went fairly well. But I want to talk to y'all about all these things, because normally I would give you these forms and tell you to make some notes. So feel free to write some notes down if you have notes that you want to make on any of this, get a piece of paper, pen out, or whatever. As we go through the second half of the class. One of the things that I have outlined for you here are the common title pitfalls, this A through J. And we're going to go through each of these, and I'm going to give you some examples. Let me start with divorce, because this is the most common thing I deal with. 50% of marriages end in divorce. So imagine the number of those that we see in closings. As far as the aesthetic of actually working with divorcing parties, it's a unique opportunity for you guys to kind of, walk through that peril of, disputing disputes between your ultimately two clients that you're working with. With divorce, we see it in three ways. We see it in a divorce that has not yet been filed, a divorce that is pending, and a divorce that is final. I like the A and C better than the B. I'd rather it be not yet filed or either completed than pending. As I told y'all earlier, I have a really difficult time getting divorce attorneys to respond to the requests. There's often lots of disputes as to who's going to hold the money if the disbursement of the money is not final. We have everything that you have to think about in a divorce that goes along with title includes who is going to get ownership of the property. Let's say that the husband gets ownership of the property, but the wife is entitled to equity out of the property. You will see divorce decrees. And I think one of the biggest misnomers for you guys is that just because a divorce decree actually says that the husband is entitled to right, title, and interest in the property, and there's usually some clause that the wife is going to give over a quitclaim deed, or vice versa, that the husband's going to give over a quitclaim deed, does not mean that they are the only title holder. So I think that is one of the biggest misconceptions that I see. Unless there's actually an order from the court vesting title directly to one or the other parties, we still have to obtain a release or quitclaim deed from the other party that is no longer entitled to an interest in the property pursuant to the divorce agreement. So just because you see a divorce agreement and it says that the wife's of interest, if you look at that warranty deed, or you look on the GSCCCA site or the Cobb County site or whatever county site that you're looking at, and you see that there's still two people on title and you can't find a deed out of one of them, we are still going to have to obtain a release from that person. And for your edification as the listing agent, they are still an owner to title to property for you. As I stated earlier as well, when it's a pending issue, I have to get the divorce attorneys to agree as to who's going to hold the proceeds or how we're going to divide the proceeds, and sign off on that. And the reason that we want them to sign off on it is because we don't know what all has yet been presented as part of the divorce to the judge. We don't ever want to interfere with the judge's ruling on something that they're in the process of doing. We don't know if there's a pending order waiting to be signed that's already out there that is counter what we're being asked to do as part of the closing just to get the deal done. And we never want to be in that process of doing something that's counter to what a potentially court order would have otherwise stated. One of the issues that we have seen is where the divorced parties want us to just split the proceeds just to get the sale done, yet the settlement agreement that was submitted to the court said that the husband was only entitled to $25,000, and the wife was to get whatever other equity was left in the transaction. Without the attorney signing off on it, we don't know if it's been amended with the court. Once the attorney sign off on it, they owe a responsibility to amend that settlement agreement with the court, and the court can then determine whether everything was financially in the best interest of both parties, and agree that it was a fair consummation of their assets. The next one that I deal with a lot is death. Sadly, it is something that we deal with often. It is a hard situation. Closings can be very happy and very exciting and a lot of fun, but they can also be very, very sad. We have had situations where children have had to sell their childhood homes because parents have passed. We have had siblings have to sell, their siblings' properties after they have passed. It's a very hard situation. There are a lot of different ways in which someone can obtain the right to sell a property after death of an owner. The most common way is through what's called a joint tenants with right of survivorship deed, which is what most married couples ask for when they buy a home, is to do the joint tenants with right of survivorship. That negates the necessity of going through and filing for probate and having a probate situation filed. It allows the surviving spouse to transfer title automatically with the issuance of the death certificate. We can take the death certificate, record that, redact out the private information on there, and record that as an exhibit or to the warranty deed, or as an exhibit to an affidavit of death of a joint tenant. There are some other ways that you can also obtain the right. You can obtain the right when it's as part of a no administration necessary transaction. You can obtain the right as part of a estate filing for probate, for probating the will in common form or solemn form in the state of Georgia. And each one of the three have unique rules and interpretations as to what the person who receives the benefit of being either the administrator or executor has the right to do. Now, just because someone is named as an executor of an estate does not mean they have the right to run out and sell a property. We have to look at what that order actually says and what rights were given by the court. The same falls for administration. Most often in administration, we have to get an order to sell, because many times with administrators' orders, they do not give the right to sell property. They maybe give the right to bring together all the assets, do an accounting of assets, and handle the combining of all of the assets and such, but they maybe do not give them the right to terminate or sell property. So we're looking at those things. If you have questions about that, my recommendation is that you obtain a copy, and there's a couple of things that you need to obtain. And if you have a pen and you're writing this down, one of the things that you need to obtain is you need to obtain from them from them a copy of the filing, which is the petition for probate. So you're going to want a petition for probate, and you're going to want to see that. And I'm typing this in the chat in case you can't see it. So you're going to want the petition for probate. You're also going to want the order that was given, any order from the probate court, and then any other information that you can provide. The petition for probate is important because the petition for probate shows us what is, the petition for probate shows us who all the heirs are. So when somebody files a petition for probate, they have to list who the heirs are, and that allows me to be able to determine who all was to receive notice of the filing, whether it be by advertisement or personal notice. The courts typically prefer personal notice. And then if you can get that and send it to your closing attorney, we'll look at that and tell you yay or nay on whether or not they have the right to sell based on that information. Sometimes we have to go to the probate court and get more information in order to be able to sell. Now, what happens when we have somebody who has died and they never filed probate, and fast forward 15 years and family has just been living in the property? I know that some of you have seen this because I get lots and lots of calls on this one. And I know that it's a tough one to deal with, but I want to talk to y'all about it a little bit because it is a common situation that we run into. If you have a client who is living in a property that they are not the sole owner of, you do not have the right to sell that property appropriately without all of the proper documentation in place. So we often will see mom and dad passed and then the siblings allowed one of those other siblings to live in a house. This just seems to be the most common one, or a grandchild to live in the house for a period of time. And now a number of years have passed and everyone is now in agreement that they're going to sell the property. And they go out and they decide that they're going to list the property. Okay, after a certain period of time, we may be able to, and it's typically 3 years or more, close on a property without probate being filed. If, and only if, we can obtain some essential documentation. One of those is an affidavit of descent from a party who has known the deceased party for a long period of time, typically 20 years. So it would be somebody who knew mom and dad for at least 20 years and can attest to the number of marriages they had and the number of children and who those children were. Now that's often hard to obtain because as people age, their friends and family age, and it's hard to find someone who can attest to that. The secondary part of this is obtaining from everyone that are heirs deeds to transfer title. They have to sign off on their interest as well. And that can be convoluted. Over the last year and a half, I've dealt with a state on a number of properties that they've sold. They have 18 heirs, and we've sold quite a number of properties for them that have a lot of heirs. And when we first got it, they had actually taken it and done some work with another law firm. And what we found was that they had actually sold it missing 4 of the heirs' signatures and agreements, and we had to go back and get those and clean it up. And so we've done quite a bit of documentation to clean those up. We work very hard to make sure it's done so that we can continue to close them going forward if there's multiple parcels, but we want to make sure that it's right no matter what. So obtaining affidavits of descent from people who have known someone that long can be really hard to do, but a period of time has to pass too. So if someone passes in December of 2019, I am not going to be able to close on a property without the filing of probate for them if they did not have a joint tenant right or survivorship agreement with their spouse without you filing for probate. Okay, so I know that's a little more than you probably ever want to know about probate, but it is something that you definitely need to just have at least a basic understanding for so that you can know what you're doing. With a trust.
Amy, before you go on with death issues, will you address, we're getting some questions about power of attorney for the deceased.
Yes, powers of attorney extinguish upon the death of the person that gave it. This is a big one, and I was going to go over this a little bit later, but since you're asking now, I will go over it now with you. Okay, power of attorney is a unique thing. It is only good for as long as the person is living. Once they die, it is no longer good. I had a gentleman one time come to me and he said, but I have a power of attorney. I don't understand why you're giving me such a hard time. I've closed 4 or 5 other homes on this using the power of attorney, because his father had owned quite a bit of property. And so the problem is your dad's been deceased, according to the records in the probate office. We found the probate for him, and he's been deceased for a period of 6 years. So everything that he had utilized that power of attorney for after his father's death for that 6-year period of time was invalid because of the power of attorney extinguished upon the death of the dad. So powers of attorney are only good while someone is living. I want to talk to you about the power of attorney. I am not an advocate, and I will never be an advocate that everybody needs a power of attorney for mom and dad. I'm not, just in case something happens. The state of Georgia is pretty good if there is an issue and someone is unable to handle their own affairs. There is a lot that can be done to help someone handle their own affairs by going through the courthouse and having them either deemed incapacitated or incompetent to handle their own affairs. And I know that's not a pretty thing to do, but we see so much fraud when it comes to powers of attorney. And I'm a big advocate of really trying to protect someone's interests for as long as they can. One of the things with powers of attorney when it comes to title that a lot of people don't understand or don't get is you will have someone, say a child that has a power of attorney for a parent, and that parent can still make decisions on their own, but they're in, let's say, a nursing home or an assisted living, and they did it for ease and complication to uncomplicate matters of taking care of their finances and taking care of their day-to-day activities. That's great. However, when it comes to use with a durable power of attorney, there's a couple of things that the title insurance standards changed a few years ago on, and most of them are now asking that if you're using a durable power of attorney, there's a couple of steps that need to be taken. How many of you just, sort of think of this in your own mind? Obviously, we can't show a raise of hands here, but have been asked to provide a letter from a doctor that says that they're unable to sign a new power of attorney due to physical or mental incapacitation. The reason that they're asking for that is they want to make sure, they really want us to use specific power of attorneys that reference the sales price of the property and what the net proceeds or estimated proceeds are going to be. At least looking at, what's going to happen and what we do with the money. With durable power of attorneys, they're often so broad, and we don't know if they have redacted those. We don't know what has transpired, but we want something more specific for a real estate transaction because it's typically a person's primary, most valuable, equitable asset that they own. With that being said, if you're looking at a durable power of attorney, go ahead and get a letter from their attending physician is my recommendation, saying that they can't get a new one because of physical or mental incapacitation. We have all of them sign an affidavit at closing. I don't know if you've ever noticed us do this. We'll give them an affidavit to sign saying that the power of attorney has not been redacted or revoked. And we also contact, wherever permissible, the person who gave a power of attorney and verify that the power of attorney is still good. So like the day before closing or the day of closing, we'll still contact them and say, hey, you understand that they are using the power of attorney to buy this property. You're still valid, you're still giving them valid permission to sign on your behalf, etc. So there's a lot of work that goes in with power of attorney, but they do extinguish upon the death of the person that gave it. So they can't use it after the fact. Okay, so moving on from there, and then let's go ahead and look at the next one. It's trust. Trust and then open loans and liens, which we'll go over together. So with the trust, these can be a little bit complicated. We actually do see a lot of irrevocable trusts that prevent the sale of property. And a lot of times you guys will have gotten it and then we didn't get it and didn't have it until we go to close and we find out that title is in the name of a trust, and you'll send it over to us, for example, and it'll have some clause in there about the sale of assets prior to the death of someone, or a problem with what is being provided. All of these things can be an issue. And I want to make sure that you guys understand that we have to have either a full copy of the trust or a certificate of a trust that was signed by the attorney that prepared the trust, telling us that there's a power of there's power to sell. So I want you to be aware of that one as well, because a lot of times people don't want to give us their trust. It has a lot of personal financial information in it, and they don't want to share that information. So I would be very cautious of that, and just know that we have to have it, because I have to know who set it up, who has the right to sign, and the powers that they have to sign, and what powers they have to do with all of the documentation. Okay. Any other questions on that one, Dana, on the trust right now so far?
Nope, not that I see.
Okay, so open loans and liens. Let me go over open loans and liens for you. Open loans we've kind of talked about in the very beginning, depending upon the type of loan transaction it is, depends upon whether or not that transaction and how we handle that for the open loan for release and when we can release them. A lot of the old open loans from the 80s are the old federal savings and bank loans. There is a thing, there's a bunch of tools out there. We have a bunch of tools that we use that we can track where a loan has went. So if one bank takes over, so a perfect example of this was First Union went to Wachovia, Wachovia went to Wells. So we know that if we have an old equity line that's out there for Wachovia, that we have to contact Wells Fargo. We know that if it's a First Union loan, that we have to go to Wells Fargo. Although we can often get these releases and get the cleanup title that we need, the problem becomes as part of that process, trying to clean it up enough that we can get it closed. be aware that most of the equity lines, when we have to get releases, because they're old, or most of the old loans that require releases, where there's been a transfer of title from one lender to another, can take anywhere from 15 to 30 days, sometimes more. I just want you to be aware of that, because if they need to go back and pull paperwork, we need them to go through their paperwork quickly and see if they can find something. Often a letter of account closure will work, but you have to remember that a lot of these situations that we see that come up with this are situations whereby someone has taken out a loan and it's just not been cleaned up, and then the law firm maybe has merged with another law firm, or they've retired. There's an attorney here in Marietta that I deal with all the time. He and I have a great rapport. He's retired and he doesn't do real estate anymore, and so I have his home email now, and just will politely email him and sometimes text his cell phone and say, hey, I sent you an email. I need just a release or proof that something was released, because one of the banks that he did a ton of work for went under when the market changed. And so he is having to give us proof that they paid off a loan at closing because they never released them of record. So, and that bank was taken over by the FDIC. And I don't know if y'all know, but trying to get something from the FDIC can be quite problematic. That's the best way I can say it for you. Okay, so let's move on now to the next item here. I'm trying to see what that is. Okay, so parties of record on title. This one can be a little bit, Dana, are you in control? Because it's not coming up for me to share my screen. Let's see here. Is it?
No, you're the host.
Okay, I'm just trying to see if I can share my screen. Guys, thank y'all for bearing with me. I am learning as we're doing this too. So
it's now. There you go. You got it.
Yeah, there we go. Okay, so it takes a little bit of time. Parties of record on title. Now, this one can be a little bit tough at times. I am not sure why we have a lot of people who want to add a third party to title to their property. I want to talk to you guys just real quickly about unmarried fiancés and boyfriends and girlfriends that are buying property. I am not an advocate for you adding someone to title who does not own the property, or who is not on the loan, or who is not part of the buying process. The reason I say that to you is twofold. I am dealing right now with a transaction that we are going to be handling, whereby we did the original closing, and we actually, every single time a buyer asks us to add a person to title, even if it's a spouse, they have to sign off saying that we have told them of certain factual information, that they understand that if that person is sued, that title can be encumbered by a suit for the third party that they've added to title. I do not like the idea of adding a person who is engaged, or a boyfriend, girlfriend. Typically, it's not my say, but I'm not typically an advocate of doing that. The one we're dealing with right now is the boyfriend bought the property. They were not engaged, but he bought the property for them. He moved into it. A year later, she moved in with him. Fast forward another year, and he now wants to sell the property, and she's on title. And we had him sign the disclosure that you understand if she gets sued or you go to sell, she's going to have to approve it. And now she wants $25,000 from the property. Of course, he's angry because he said she's never paid him one dime for the mortgage. And she's angry because the relationship is deteriorated, and now she wants money from the transaction. And guys, it's not always the woman asks for money. We've had this in the complete reverse as well. But it does become a really big problem. Now, if they're a spouse wanting to be added to title, that's more of a probate issue and more of a transactional issue, where somebody wants to handle not having to go to probate. God forbid something happened to one or the other parties. In this situation, he added her to title prematurely, and now he's having to fight her to get her off title, and she wants money for that. I would caution anyone to adding someone third party to title. Even parents, I say the same thing to them that I say to a young couple. If you add your son or daughter to title and they get into a car accident, or they don't pay a credit card debt and they are pursued for that, those things can come across title to their property and inhibit their sale, or inhibit the value of the equity equity proceeds that they're going to be able to get. So I just want y'all to make sure that when you're recommending that they add a third party to title. Now, if that significant other, whoever that may be, has given them the down payment, if that significant other is on the loan or is contributing to payments, that's a whole different thing. But that's really not your or my responsibility to get into. I just want you to know that from my office, we have them sign a disclosure that you understand that it's a risk to add any third party to title, especially when they're not equally obligated to the note. And that's where I would say just be careful with your advice that you give them, because I do see a lot of my realtors say, oh, you are getting married next month, go ahead and add yourself to title. Well, okay, now you've kind of stepped out there and put yourself out there. What happens if they don't get married? What happens if something happens and their relationship deteriorates before the wedding and he's the only person or she's the only person who's put any equity in this property? So you're putting yourself a little bit of risk by giving that advice. I just want you to be careful. Again, not my job to say whether it's the right or wrong thing for any couple or any group of relatives or family or friends or whatever anyone may be. I just try to make sure they understand that if you do this, there are some risks, and here are the risks for that. Okay, now moving on from that, if you have questions, please put them in the chat and Dana will get them to me so that I know where they are. The next one is marriage. Okay, I get a lot of questions after closing on this one, and I'm totally happy to answer all of those questions as they come in. But we get a lot of questions after closing of, we have now gotten married, how do I adjust my name on title, etc. I do recommend that they try to do it earlier in the process of ownership of the property as they can. And the reason that I say to do it then is they often lose marriage certificates and they often lose pertinent data information that we would need to be able to show that a name change had taken place. If they buy the property, for example, and I'm just throwing this name out there, if there's a Jennifer Smith on here, it's just a common name I'm using. I'm not referencing you. Jennifer Smith, and let's say Jennifer Smith is my person who is on the title, and she now gets married. And when she gets married, she decides that she's going to change her name, and her new name is Dennis. So now she's Jennifer Dennis. So when she goes to sell that property, we're going to have information showing that Jennifer Smith is Jennifer Dennis, and it's typically a marriage certificate. The same thing when we have Jennifer Dennis go from Jennifer Dennis because of his divorce back to Jennifer Smith. I'd have to have her divorce decree if it wasn't filed in the same county as the property is located. So with that, in that regard, just know and understand that we're going to have certain pertinent documentation and information in order to be able to proceed forward in making sure that name change is done properly. I just say go ahead and do it on the front end because you already have the documentation. Let's get it done and move on. And it's one last thing that you have to deal with. Okay. I think the hardest thing that I have to deal with when I deal with someone adding a third party to title for unknown reasons, sometimes it's a situation where there's a death and the court maybe orders it, is when we're dealing with minors. I know state laws are different from state to state. I totally understand that. I get it. One of the big issues that I do see, though, is in divorce situations where a husband or wife, ex-husband or ex-wife, thinks that they can have a situation where if they add the minor child to title to the property, they will be able to protect that asset for that minor child in the event something happens to them from the ex-spouse. Okay, there are easier ways to do it. I.e. a will or trust, something along those lines. So I am a big advocate of you going that route versus putting a minor on title. And here's why. When you add a minor to title, let's say that it's as part of a divorce. Let's start with that scenario first. When you add in minor title to divorce, as you know, there's usually typically a guardian ad litem appointed to make sure that the interest of the child is met, especially in cases where there is accusation that there is some form of mismanagement, mishandling, or some form of potential claim of abuse. There is often a guardian ad litem appointed to make sure that their interests are met through the divorce process. As part of that, if that child is then added to title later, guess who we have to go back to get approval to sell? The guardian ad litem. So sometimes children were being added to title as part of the divorce proceeds or process because it was some agreement that the equity from the home, a portion of that whenever it was sold, was to go to the kids in trust. And so they would add the kids to title to property to be able to accomplish that. But then the guardian ad litem from the court would have to come back and say, yes, we believe that they are handling this properly and this is what we want you to do with the funds or whatever. Likewise, it's hard to get a minor's name off title because they can't sign. And often just having the parents agree is not enough. So I want to give you that scenario. Now, where there's a death, we've had a couple of situations arise where someone has passed and they have left title to minor children, and they did not have someone qualified for a trust yet. We have seen a couple of situations where the probate judges have ordered the title be vested into the name of the minors. But then you look at a situation with this where you have a potential problem with who's going to maintain that property. The minors aren't working. Who's going to do all of those things? So it's really up to the courts on how they handle that. Typically, now what we see is they appoint a trustee to oversee the minors' interest in the property, and then they will allow us to sell under certain criteria, and they'll tell us what needs to be done in order to sell and what to do with the funds after that. So there's a lot that goes into adding minor children to title. Again, I'm not a big advocate for it in most instances, but it typically comes from a divorce or a death situation where something has happened and they've vested title. Now, the next piece of this is waterways and lakes. Many of us get to enjoy the lakes that we have in this area for Allatoona and for Lake Lanier, and there's the Chattahoochee, and we have all of these wonderful rivers and lakes in this area, and there's a lot that goes into the process of buying a property that is on a waterway. Many of the properties on Allatoona sit on Corps property where they lease the property directly from the Corps, but they don't actually own the land that the property sits on. And in those cases, a lot of those are not allowed to even be year-round homes. If you're not aware of the issues that go along with the waterways, I would certainly look at that. We had one come up last year, and I've only been able to find one attorney in the state that's ever dealt with it before, where there is a dam that is for a small river in North Georgia that the water runs through there, and that dam is not maintained by the state. It's maintained according to title by the title property owner, and the owner did not know that when they bought it. They came to me out of a referral after they bought it, and it needed some repairs to the tune of about $60,000. And we were able to find an attorney that had handled this, unfortunately at his own personal demise, on a situation that he had with a waterway and a dam, and had a lot of information that he was able to provide to them on that. So I would be significantly careful when you're dealing with waterways and lakes and streams. If you buy a property that has a stream, there are some stream buffer requirements. We've had someone sued that came to us after the lawsuit was filed, saying that they were violating stream use rights, and they had went in and literally filled in a stream because they didn't like where it was, and diverted the water, and so that became a problem. So I would be significantly cautious on that. Try to find out as much information as you can on the front end about who owns the land, who maintains it, is it a lease, is it a year-round dwelling, do they have rights, to the waterways, do they own the waterway? All of these things are pertinent questions that you need to be asking on the front end. Look, you don't have to be the attorney that knows everything about all of this. What you do have to be cognizant enough is that you understand there are potential risks, and you need to get the information and take it to your closing attorney and say, hey, this is what we found. Can you help me sort of explain this to my client? And your closing attorney should be willing to do this for you. So they should be willing to get on the phone with your clients and explain, hey, here's the risk, here's what's going on, here's what the title is going to show. And many of them can pull things, online just to kind of get a preliminary look at stuff to be able to help you with that, because we do that a lot. And I'd rather you find out on the front end than find out when it's too late to fix something if there is an issue or a question on it. Now, easements. So the next one, and I'll share the screen a little bit for those of you that were writing these down. The next one is, oh, hold on a minute. I am seeing a lot of questions coming through. I'm going to try to see what y'all are writing real quick and see if there's a couple of these that I can answer for you really quick. Let me see what you're saying here. Okay, we have an issue on a current contract which has delayed closing by a month. How long does it take to resolve a title insurance issue? I'm wondering if the title insurance is really worth it. Okay, Beverly, yes, absolutely the title insurance is worth it. And again, just as I said in the beginning, just because you have a title issue that you believe should be covered by title insurance doesn't mean they're not going to take the necessary steps to clean it up immediately before they allow you to proceed forward with closing. It doesn't mean that it will never close. It may just take a while to get it done. One of the big common issues that we see right now is tax sales, where they have not actually foreclosed on the property and done a suit to clear title. And they move forward with closing. Those are some of the issues. And, you know, it just depends on what the title issue is, but a suit to clear title can take anywhere from 6 months to a year or two. It depends on the county. It depends on where it's located and the process is where it is. We have seen title insurance issues take a couple of months to clean up because the title insurance company says, you know what, this is a big risk and we want some title clearance worked on. Michelle is asking, I have a client who's retired and bought a property because of income coming from retirement investments. The loan officer asked for a cosigner. She had a sister-in-law, deceased brother's wife, sign. Michelle, I'm not sure what you're asking me there. Are you asking me if she should be on title to the property? If she's on the loan, she's going to be required to be on title to the property as part of the loan process. They can remove her afterwards if she approves to do that. But in most cases, I don't know of any case where a lender will allow for a cosigner of real property that they're not on title to the property. They have to be an owner to be able to collateralize the property on the loan. And then this is if a couple engaged buys in both names, when couple marry and wife changes name to husband's name, does the title need to be changed? Yes. I would recommend they go ahead and change the name on the title just to clean it up. And in your scenario, they're engaged and they buy it together. So I assume from that they're both on the loan. Yes, there are a lot of, Sue, you're exactly right. On Lake Lanier, there's a lot of rules pertaining living next to the core property that people don't understand and don't know about. If a party is on the loan, they need to sell or refinance to get off title. Yes. Okay. As part of a divorce process, good point, Dana. As part of a divorce process, just because a divorce decree states that someone is entitled to property or that someone else is required to pay the mortgage does not negate the responsibility of the original borrower. The court does not have the right, unless there's a hearing where the creditor appears, to remove a debtor from a loan. So in other words, let's say husband A and B and wife A and B get a divorce. The divorce decree says that the wife is to have right, title, and interest of property, and she's responsible for making all the payments. The note was originally in wife and husband's name. The note is still in wife and husband's name, and which means that if she doesn't pay, it can still damage the husband's credit. The only way to get him off the loan is for the lender to release, which I've never had a lender do this, release their equitable requirement to pay or their debt obligations, or to have the wife refinance or sell the property to get his name off of that loan. Remember, when you're dealing with divorce issues, those are all debt to income issues. The more loans they're on, the more responsible they are for making, the higher their debt to income ratio is. I'm sorry. I'm seeing chats come across and they're catching my eyes. I'm trying to talk, so I apologize. Okay, so that's part of it. And then I saw another one. Does your title insurance clear? Best case, why do I need title insurance as well? Okay, so just because your attorney does a 50-year title search to make sure everything is clear does not mean you do not need title insurance. There are a lot of things that title insurance protects that we would not see in a chain of title. I'll give you a couple of examples. We've had a couple of courthouses in the state of Georgia that have caught fire and deeds have burned. So there are things that we would not be able to find because we have to go back and research some of that. There are situations where we have seen things that were not clearly defined in the deed records or not cross-referenced. There is actually a subdivision in one of our neighboring counties over here that Dana and I have actually had to deal with on a couple of different occasions, where the 55 and up community was bought out by a new developer. New developer did a new plat and extended the property that was included in that subdivision. That plat never referenced the old plat. So there was no cross-reference at all that it was the same as the old plat. We used the old plat reference on our closing because there was no cross-reference whatsoever. We then got a notice from the county. They caught it and sent it to us, and we had to do some cross-referencing with the plats. I actually filed an affidavit in the county, and I've had a couple of attorneys call me and say, thank you for doing that, because we wouldn't have found the new plat either because it doesn't cross-reference. And because it changed all the land lines, the lot lines. So there are things that are, even with a 50-year title exam, we would not know. And there are things that go beyond 50 years that we do not see if you stop at a 50-year title exam. So the title insurance protects the owner of the property through the chain of time. So it doesn't just say we're only going to protect you for the last 5 years. But there are things that we would not otherwise know about. And there's also a thing called what's called the gap period. So let's say that I have a closing on Friday. My title exam was probably finished last week. I might look online to make sure there's no new liens filed. But there are certain things that you can't find online as easily as when you're in the county records, or it's not as efficient, if you will. That gap period may not cover, if you don't have title insurance, the gap, the title insurance would most likely cover that gap period if something was filed. This is often the case in new construction. Even when we do a 50-year title, we don't know if the builders have paid their material man, and if they haven't, or a prior owner paid the material man for some work they did. If they haven't, we don't know that. Even with the affidavits that are filed, and it could become a lien on title to the property for the new buyer, especially if it's filed prior to my deed being recorded. So yes, I'm an advocate that you need to buy title insurance regardless of how long they've gone by. I did have a question for the request for why a 99-year title exam. If you have someone that's wanting us to check mineral rights, those have to go back 100 years. You can do a property search, and we can do it for as far back as you want to go. It just takes extra time, and it's a more costly approach. And if your buyer wants that, we're happy to do it. Mineral rights searches are automatically 100 years, and it goes by hourly rates. Okay, I'm going to move on from a couple of the questions real quick and move on to the next thing. Just
Amy,
because I
Amy, just one thing. Well, just one thing. I'm going to ask for the host back. I'm going to launch a poll, everyone. That's going to be the course evaluation, but I have to do it as host. So if you'll give me the host back,
yeah.
I'll launch the poll, and then I'll give you the host back again. There's questions about limited warranty deed versus general warranty deed, and how much does title insurance cost?
Okay, limited warranty deed. Are you the host now? You've got it. Okay.
I'm the host. I just launched the poll. You guys will all see a poll. If you will answer the questions, these are anonymous. And this is what we are using for the course evaluation. And then Amy, I'm going to give you the hosts back right now.
Thank you. Okay, so as far as what, I'm going to X that out of that because that's like distracting for me. As far as what we're seeing with the title insurance, it runs typically about $1,000. So if you're looking at it per dollar, the last time I ran it, which has been a few months back, was running about $345 to $355, depending on who the title insurance company is. They all are pretty close in line per thousand. So if that gives you a little bit of leeway on what you're looking at, they really should not, we have to charge under the insurance commissioner's rules, we have to charge whatever the rule is on that. And so whatever this published rate is on that. So we have to charge the published rate. I don't have a say in what the cost of title insurance is. I used to charge $1,000 for lenders and $1.50 for owners. And then when they came out and said, we have to change it, then I have to change it. So I have to charge whatever the book rate is. A lot of them are saying that they are frozen. I don't know if you see that, Dana. A lot of them said they submitted it and then became frozen. I'm not sure what that is. Okay, so that is the cost on the title insurance. As far as warranty deed versus limited warranty, Warranty deed goes back through the chain of time. Limited warranty deed is given by the seller only for the period of time. They're ensuring the period of time that they own the property for things they knew about. Let me talk to you about reserved interest. Reserved interest are where someone has like something like a life estate. Okay. A life estate interest is often given to, we see it in situations where there's been a marriage that resulted from children, then there was a divorce a lot of times, and then the second, they want to leave their asset of their equity of their house to their children, but they want to make sure that their spouse or significant other still has a place to live while they're alive. So they'll give them a life estate interest in the property, meaning that they can live there for the term of their life until they decease, and then the property reverts fully to the children at that time, and then they can do with it what they want to do. So that is, what we're looking at with reservation interest. They can quit claim deed or deed out that life estate interest to the heirs at any time, and say, I no longer want to live here. I'm going to go live with a child or something along those lines. We see that a lot where they say, I don't want to live here anymore and I want to move in with my other child. And they can give up their reservation of life interest. Title problems. One of the big issues that we deal with is full title examinations versus online title examinations. I'm an advocate, big advocate for full title examinations. Attorney reviews of title. I would make sure that your law firm is actually having the attorneys review title. A lot of law firms have their paralegals clean title for them. I'm not an advocate of it. In our office, we do the title exams, and both of our attorneys actually look at every one of our titles. A big advocate of title insurance, as I've already told you. Who's cleaning the title? With our office, our title is cleaned by our attorneys and cleared by our attorneys, and then we give directive to the paralegals on what needs to be done in order to make sure that we are all on the same page, and they may contact you about what we need, but it's because we have given them the directive of what we need to clear the title. I'm going to share, can I share screen, Dana? Can I share screen for the last part of this?
Yes, you have the host now, so you should be able to share.
Okay. So at the bottom here, if you want to copy these down with you, you don't have to. It's really up to you. But providing the correct information to the closing agent at the time of our or prior to the contract. I really want to hit on this for just a couple of minutes before we depart from this meeting. We often will have you all submit to us a contract that says something along the lines of we're selling the property at, let's see, 1234 Mars Hill Road. Okay. Unbeknownst to us, 1234 Mars Hill Road is the property that we're selling and has the house on it, but we may not know that they're also intending to sell the 3-acre tract that they own next door. If you don't put that in your contract, I am only selling what your contract says, even if I see that they own a property next door, because that's not what you've contracted to sell. For our part of it, we often have transactions where somebody says, I'm going to sell the house, but I'm going to keep the land. Or I'm going to sell the land, but I'm going to keep the house. So for us, it's not an issue to go out and investigate. And I might not even notice that they own property next door, because when I examine title, I'm only examining the title within the corners of the boundaries of the property that I'm actually looking at. I'm not examining the neighbor properties unless something in that chain tells me there's an issue that I need to look at something around there. We often have someone that will buy a property with land. They will buy the house with the land because of loan requirements. They can only put so much land on the loan, and then they will buy the land separate from it. So there's separate deeds. So unless I know that there's more land, I won't be aware of that. I recommend strongly that you put 1234 Mars Hill and 000 Mars Hill. Try to find both tax parcels. Cobb County, a lot of these counties have phenomenal tax assessment website. If you don't use Q Public, it's a paid subscription. You can use Q Public and go on there, and you can actually move around and see what properties they own in that area if you know they own something, and get us both parcel ID numbers, and then go into the GSCCA website and let us pull the deeds, or you pull the deeds and attach both deeds to all the properties to the contract. Doing a special step that this property is intended to include not only the house, but an additional 2-acre tract that is adjacent. Give me something. The security deed is not a foolproof way to look, because the security deed often does not encumber the extra property lands, because there are some requirements on how much the land cost can be over the actual dwelling. It can't be more than a certain percentage. So a lot of lenders will come back and say, we can't sell this much land with this house. We're going to have to divide it out to do the loan, but then they can buy the other land separately. So those are some things that you need to really be looking at. And then you really need to just special stip it. We read your contracts. So some of you that have closed with us know that I will go to and call you and say, hey, I'm not really sure what I'm selling here. There's, I get a deed back and it'll have 4 lots on it, but your property only shows me that I'm selling 2 lots. And that's okay if we're only selling 2 lots, but we'll often check it because it doesn't match what the actual deed says. We most often see it in reverse, where we have a parcel, but we don't have the additional section of that parcel, if that makes any sense. So we need you to tell us that in the contract. Tax parcel IDs, although not the most reliable thing, I really, really want you to try to get those. More importantly, do a special stip if you're not sure. I know that I've had some of y'all tell me that in dot loop and FMLS, when you're doing the electronic signatures, it doesn't give you enough space to put like 1, 2, 3 and 0, 0, 0 sometimes. If that's okay, that's okay. Do a special stip for us, okay? Something that I will be able to take it and say, here's where I'm at with it. Please give me the information so that I know to look at that and know to come back to you and say, okay, I'm seeing this, but I need to know what else I'm selling too. Because unless you set it out there, I have no way of knowing what I'm supposed to be selling unless you tell me that in the contract. And quite frankly, I'm only obligated to sell what your contract says. And so we have actually had a couple of transactions come back and say, oh, they were supposed to get the 3 acres adjacent, or they were supposed to get the 1 acre next door, but your contract only has 1 lot in 1 property, and that's what we sold. In most of the cases, we're able to go back and get them cleaned up really, really easy. But you have to think we don't want to have to go back after a closing to fix something if it could have been resolved with a contract stipulation. I'm trying to get into ask some of your chat questions. Is there a website of public record for surveys? The surveys that are recorded of public record are on the GSCCA website or the county website, and they're recorded of public record. You can look by address, like for example, Cobb County, you can go on there and look by address. And if that address is referenced on the survey, it'll often pull it up if there is one. Plat records will allow you to go in and look at that as well. So you can go on there and look on the GSCCA site or the county maintained sites for that. Dana, are there any other chat questions? I am not able to easily scroll through that.
There's a lot going through. There was a question about if the parties have the choice of choosing a title insurance company. And then also, I think it would be a worthwhile discussion a little bit about what good and marketable title means per the contract with respect to title insurance.
Absolutely. Okay, so let me start with title insurance. No, you don't have the choice of what title insurance company to pick at the closing table. Now, your buyer can decide that they're not going to buy title insurance through who the agent is insuring title through. If they choose to buy it through another company, I had a lady that I did a closing for that she worked for a particular title insurance company that I do not underwrite for, and she wanted to get it through them, which was fine. She just didn't buy it through me, and then she went to them afterwards and got that done. So they don't have to buy title insurance at closing. It is optional. I don't recommend they don't get it. We underwrite through a couple of different title insurance companies. I chose the title companies that I underwrite for based on their viability and how long they had been in the market and what their financial standings were, because if I ever decide to retire, I don't know that I ever would because I'm kind of a workaholic. I have to be doing something all the time, but if I do retire, I want my clients to always be protected on their title insurance. So I'm a big on looking at the viability. There are some newer ones that are in the market. I don't know a lot about those, but typically they can have a choice, but they would have to go to those other title insurance companies and have that done separately from what we're doing at the closing table. And each closing firm has certain agencies that they write for. And that's just the way that it works. As far as, what was the other question, Dana? I'm sorry. Oh, marketable title.
Yeah.
Okay, so Q Public is the name for the tax assessor. If you want to go look at tax plats, I see a chat question on that, Q Public. So if we're doing a closing, we may be able to insure title through the title insurance based on us being able to get a clearance. For our policy for my office, if we clear anything, we always get a letter from the title insurance company, and it is submitted back to the title insurance company with our policy. Here's why. Again, if I'm not around or want to be able to pull something, and our title insurance company has told me that they do appreciate me sending this back with their policy, it's because I want to be able to have proof that they insured it, because I don't want them to come back and say, we didn't agree to insure that, we're not going to honor the claim. If there ever was a claim, part of the insurance is to make sure that they're covered. Now, there are risks that aren't covered, but there are a lot of risks for title insurance that are covered. So I want to make sure that I am protecting that client. You can have title that is fully cleared, no issues. There are some titles that, as much as we try, we cannot fully clear them. And I want to be very clear on this. We often cannot release old open loans. But what we can do is track down the prior attorney if we're able, and get a copy of where they overnighted or wired the letter, the payoff, where they sent the letter of notice for them to terminate the lien and release it, a copy of the closing disclosure. We can record affidavits with that and actually get that recorded of public record to clear it. But a lot of times we're unable to do it because those closing transactions took so long, or took place so long ago. I'm unable to do that. So the only way for me to move forward is in order for me to clean it up through a title insurance issue. Does that help? Is that what you're looking for? Okay. All right. So anything else that you guys have a question on? We have about 5 minutes, it looks like, I think. And so I'm happy to, do that. I have 3 sets of documents. I am happy to submit those out to y'all if y'all want them with all those surveys on them. I don't mind sharing that with y'all if you'd like it. If that's what you would want, and that way you can just go back and look at them. I do highly recommend, though, that if you have a survey, just please send it over to your title insurance, to your closing attorney, so they can look at it and they have it as part of the documentation that they have. Does that make sense? Okay. Okay, yes, I'll get that over to Dana, and Dana can share that as well. Yeah. Are there any other questions, Dana, that I'm not seeing coming through the chat because they're scrolling so, golly, you guys type fast.
A question about the cost of title insurance, cash transaction versus a mortgage transaction. A lot of people asking. Amy will send me the handouts, and at the end of class, if you guys stay on, I'll show you where the link is where you can access them. Acquiring title through quitclaim deed or assuming mortgage title and conventional. Those are 2 of the most pertinent questions I see. It is going quickly.
So let me just tell you, the quitclaim deed, I am not an advocate of transferring title by quitclaim deed. As you guys all know, when you transfer title by quitclaim deed, it's not saying I am assuring you or insuring you that I have a title interest to this property. What it's saying is, if I have any interest, it's yours. But I'm not insuring anything. So be careful with that, because as the market is turned, I am fearful that we're going to see people maybe lose their homes right now. There were some mortgage lenders in the market that were selling on the flip side after foreclosures, and they were only given title by quitclaim deeds. And the title companies really firmly objected to it. So I want you to be careful with that. I'm not an advocate of quitclaim deeds just because it doesn't give you any way to go back if there's ever an issue on the prior person for recourse if they did something wrong. As far as, what was the other question, Dana? There are so many going through. I was trying to keep up with it, but there's just so much going through.
Cash, difference in price for cash.
Yes. Okay, so on the title insurance, when you get a cash deal, there is $100 issuance for the lender's title policy. So if they convert to loan, we'll divide it out between what part of that is the lenders and what part goes to the owners. So let's just use a nice round number and say that the title insurance for a cash deal is $900. But if they get a loan, it should be $1,000, but it might be broken up for $400 for the lender and $600 for the owner when you see the final one. So it's usually $100 difference to issue the lenders, but the way that it gets divided once a loan transaction takes place is why you see that difference. But there's really not much difference between the savings on a cash versus a transaction with a lender's policy on it.
Another question about title insurance: if somebody assumes, it went fast, assumes the property or assumes the...
Okay, we see this a lot where we have investors or someone that will go to an individual directly. Sometimes it's parents, and they give a quitclaim deed over a title to their property to their child. That policy is terminated upon the conveyance of title. So if we have somebody that quitclaim deeds a title out of their name, that policy is no longer valid without a new amendment to that policy or without some form of endorsement. Be careful, because you need to be really careful with this piece of it, that a lot of people will transfer title on a policy from an individual to a corporation. And there are some rules about that piece of it too. Who owns the corporation? Who has the right to it? Is that policy going to cover for them to transfer it over? Or do we need to do an endorsement and get approval from the title company to endorse it to the new owner? So be careful with that. But conveying title, generally speaking, and this is not a hard, firm, fast rule, generally speaking, conveying title out of one party's names into other parties' names would terminate the insurance endorsement for the title policy. Does that help? Is that what you're asking? Okay, great. Okay, can transfer title insurance be transferable from one person to another? Typically no, because unless there are certain criteria in place, like if it's a husband-wife transfer, we will often see endorsements done to add the wife to it. This is a big reason that we ask y'all to tell us on the front end if a husband or wife is going to be added to title and the other one is on the loan. The big reason for that is because we need to check down their name in the deed records to make sure there's no liens against them, to ensure that we're not adding somebody that has a lien against them for the lender. Doing it on the front end is always the best part of that. Okay, any other questions for me? Is that it? Okay, Dana, I think that's it then. I think I got it all in.
Amy, as Amy is going to stay on and answer any questions, I thank you guys so very much. This was fabulous information, Amy. I know it is scrolling very quickly, but tons and tons of compliments. And I appreciate all of you guys with your participation, the 400 people on here. Again, I'm going to share my screen. And that is that information that you guys need with addresses and where to find information about. We will email address. The CE credits will be recorded in 3 to 5 business days. There's a lot of reports we have combined to get a CE roster. Heidi Kelly is the coordinator of the school, and this is her email address. If you have issues, please don't email her right now. It takes her, again, 3 to 5 business days to put all these reports together. And then down at the bottom, you will see a link. That is where you get a copy of the recording once I post it, as well as any documents that will be posted for this class. So when Amy sends me documents, it will be posted there. But again, I'm going to leave that for a little bit so you guys can copy down those email addresses and information. Amy is still on to answer any questions for you guys.
I think everybody is muted. I think what she's asking is where we have somebody that's trying to buy a property by assumption, and I'll go over that real quickly with you. What that really, if that's the question she's asking, what that means is that someone is wanting to buy a property and maintain the current mortgage that is on the title to the property. There is a lot of risk in doing this. I don't recommend it for everyone. There are certain situations where I know that it can be very helpful for all the parties involved. It's typically an investor situation or someone who does not have the credit worthiness to be able to get a new loan, or it's an investor situation where they don't want to expend their own capital to purchase a property. There are a number of different risks. So the loan is still debt to income for the original debtor, and they're relying on that new owner that's going to be making those payments to make the payments on time. That's an extraordinary risk to them as well. If they make a late payment, it still impacts the borrowers, the original borrower's credit. There is still an impact to the original borrower for debt to income. If it's an FHA loan, that can be a problem. There's also a risk in if the lender finds out, they can call the loan due, and then the new owner that has possibly put a tenant in there, or who has possibly done some form of remediation on the property as far as expenditure of upgrading the property or whatever, they would potentially lose what they have put into it if they don't pay it off, if the lender calls the loan due. So there is risk to doing that. I really firmly recommend before a seller does that they really check out the person that they're giving this right to. When the market tank happened, the first go around that we saw back in 2007, 2008, I received a lot of calls from people who thought they had sold a property, but what they had in essence done was assign the property to a new owner. And they were calling me saying, I'm trying to buy a new house, and I have found out that the house that I sold X years ago is in default and being foreclosed on. So there is a great risk to somebody doing that. So they really need to know all the ins and outs of it and really need to understand the risk that they're taking in doing it. But in desperate times, people do desperate things. And so some people are like, you know what, I don't care. I'm fine with doing it. But there is a due on sale clause in the mortgage. And the lender can call that entire loan due. And that's going to hit their credit if they do that. Does that help, Tina? Is that what you were asking? Dana, I can't, let's see if I can unmute.
I'm sorry, if they do the assumption, Dana, what it sounds like is it's not a final transaction. Is that right?
Well, they will no longer own the title of the property, and they will no longer have the interest right and title to the property. But their loan and their credit will be getting utilized for the next owner to use, and that debt to income is still on their credit report. So we have seen a couple of people do these assumptions thinking that they're doing a sale, and they go to buy another property and don't qualify for that property because they have a debt to income on another property and can't afford two loans.
I think I'm confused. Can I get your number and have them call you? And you can.
Sure can. Yeah, it's on that screen that Dana put up if you want to grab it from there. Mm-hmm.
Okay, great.
Yeah.
Thank you.
All right, no worries. Any other last minute questions? Because I know that we're winding down on time. Is there anything else that y'all need to ask or want to ask or are curious about?
Yes, Amy, I have a client interested in waterfront property, and I was wondering what were some of those questions that we should ask up front?
Okay, depending on where the waterfront property is located, you're going to want to, if it's one of the lakes, you're going to want to know if it's owned by the Army Corps of Engineers. If some of the major rivers here are also owned and managed by the Army Corps of Engineers. If it is, there's going to be typically a lease on the property. You're going to want to find out if it's year-round availability for living in the property year-round as a primary home. And if you don't use it as a primary residence, if it's not allowable for a primary residence, then your client needs to understand that they may not be able to stay in it more than so many days out of the year or what have you. Also, if they're wanting waterfront property, the dock issue becomes a big issue. If it's a lake, a lot of people want to put a dock out there. The Army Corps of Engineers they would have to go to them to get approval to put a dock out. All of that needs to be investigated by the due diligence period. I will tell you, I definitely think when you're buying waterfront or riverfront property that you need a longer due diligence period because there's so much that goes into it that they need to look at.
Thank you so much.
You're so welcome. I hope to see all of you guys in a closing soon. I know that we are missing you guys as part of our closing process. I'm ready for you guys to return to closing. If I can ever be of assistance or my staff ever be of assistance to any of you, please don't hesitate to call us. We would love to work with y'all. Again, I'm Amy Davis with Davis & Associates. So it's a pleasure.
Hi, Amy. May I ask you one more question?
Yes, ma'am.
Yes, how long to take the record for, when the after closing?
Well,
record the property on the county. like a Fulton County.
Okay, so Fulton County is unique right now. We're seeing we typically see longer delays in Fulton County because it's a very populated county and there's a lot of transactions that go on. It depends on whether or not you record it in the county or you record it via e-recording. Sometimes you can see longer delays on one or the other depending on how they're working those processes. I would say that you can typically, if it's sent out pretty quickly after closing, within about 2 weeks, you should be able to see that deed online. And it'll revert back to the day that they receive it. So the day
I have one property, actually it's a condo, and it was closed on the February 18th. And they still show the previous owner's name on the Fulton County. It's 2 months now.
Are you talking about the deed records or are you talking about the tax assessor records for Fulton County?
I just went to the Fulton County record, search the property.
Okay, so if you're searching through just that general website that they have where you can look at the owners, that's their tax assessor's office. That is not going to be updated until the new tax bills come out.
Oh, okay.
So that will not be updated. With the deed records, it's going to depend because Fulton County's record rooms have been closed because of the Corona thing, and they're doing a lot of the work from home type of situation and doing a lot of the e-recording, and a lot of law firms are not doing e-recording yet. So some of them are holding them until they open back up to send the deeds in. I don't know what the situation for your attorney is. I would call them and find out. They may already have the recorded deed back.
Okay.
I don't know.
Okay,
but you just may not be able to see it of record yet.
Okay, thank you.
Okay. You're welcome.
I have a quick question.
Yeah.
If two person they own a property and they have a title insurance, if one person's name has been removed from the property, the title insurance still cover the other person?
Yes.
Okay.
Yes.
All right. Thank you.
Okay, Amy, I have a question. Is the mineral rights goes with the new buyer? Is the old buyer has any rights on the mineral rights for the land of 10 acres and more?
I didn't understand your question, Ruby.
The mineral rights goes with the new buyer when we close the property, or the
unless there's a reservation of mineral rights, the mineral rights transfers with each new owner. And that's why we have to go back 100 years on mineral rights searches, because those mineral rights run with the land and not the owner. And so we would have to go back and check and see if there's any mineral rights recorded in the past deed history. And it takes quite a long time.
Amy, can you answer this one last question?
Yes, ma'am.
Great. So I have a situation. A buyer purchases a new home in February.
Okay.
3 weeks later, turns around to refinance.
Okay.
So the loan is paid off of the original home. However, there was an option at closing for the buyer to consider purchasing the owner's title insurance. They now want the owner's title insurance.
Okay.
Should they get that from the new refinance, or can they still have that window to get it back from the original?
You can get title insurance from any title agent in the state or any of the title agencies directly. Where you're going to see an increase in cost, though, is they may require that they go back and do a new title exam or update the title exam from the day of closing or previously forward. So you will see a potential increase in cost just to be able to update the title to make sure nothing new has been recorded.
So do you think it would be best to steer them with the individuals that they did the refinance through, because all this occurred in within 60 days? The purchase.
I mean, they can, either one, honestly, either one, because it's been such a close time. Either one of them should be able to issue that. I would go back and just check with both of them and see what they're going to require. Many law firms will require, no matter what, that they update the title if they're issuing a title policy for you, though. So they may get hit with a title insurance update by either one of those.
Okay, thank you so much.
You're so welcome.
Amy, there was a question about, is there a website to go look to see who owns a creek?
Well, that depends. That is most likely going to be a title exam between the properties that surround the creek. The issue that we get into here is that the creek beds are often the dividing property lines for a lot of properties. So if it's the dividing property line, it's going to be each owner owns half of it to the center line of the creek. We have seen a lot of creek bed issues come up because of the floods since 2009, and even more recently with all the waters that we've seen rising, where the creek bed shifts and causes an acreage variance between the two properties because the center line is between the creek beds. The way that you would do that is typically a title examination. It's usually somewhat difficult to be able to find just going online to see who owns a creek bed without doing a title examination of some sort. Does that help you? It's usually going to be a title examination of the surrounding properties for it to see who owns it. But just finding out who owns a creek bed, a lot of creek beds are state maintained or considered state protected. So we would have to find that information out through a title exam.
All right, I think that's it. Anybody else? Do you have to buy new title insurance when you refinance?
No, ma'am. Title insurance is good from the day of ownership to the day you sell it. Refinancing has nothing to do with owner's title insurance. For those of you that are in our area, in the Cobb area, Paulding, Douglas area, feel free to stop by the office. We have a great pamphlet for you guys that you can pass out to your clients regarding the importance of title insurance. We have one that is a realtor-directed pamphlet that kind of tells you a little bit about what title insurance does to help you be an advocate for your client. And then we also have one on wiring instructions that you can give your buyers and it just basically sets out that these are the risks in doing a wire, and these are the federal wire protection recommendations to protect yourself when you're sending out a wire. So we have a lot of those kind of pamphlets. If you'd like them, feel free to stop by the office and pick some of those up. Give us a couple of weeks though. We're still, although the governor's order has released people to go back to work in some industries, I want to make it very clear to you that right now we are still under a shelter in place until the 30th, I think it is. And then after that, it appears from what we're hearing that they're going to set guidelines for opening this up a little at a time. We don't know if the guidelines are going to continue with the CDC requirement, which is still the 6-foot separation rule, and how that's going to be implemented, because we're hearing right now that a lot of the companies are going to have to provide their employees masks and gloves and things like that. So we're not sure when it's going to be, efficient for everybody to start coming back to closing and in and out of the office all the time. But if you'd like to do that, feel free to stop by once all of this kind of slows down a little bit and pick some of those up. Any other questions for me? Because I know it's time to sign off. I have so enjoyed doing this today with you guys. I know it's different. I know it's not the norm. I know it's a little convoluted in how we have to do it, doing the online training, but we're going to continue to put these out for as long as we can. And Dana and I are working on some new ones. So very excited to do that for you all. And it's been interesting seeing 400 names fly across that chat very quickly all afternoon. So have a great afternoon, everyone. And thanks so much for allowing me to do your class for you today.
Thank you. Enjoy.